Mr. J. Lashkar is out of station.
21, what is the position? Goswami, 21. CD, we have not received. It is a charge sheeted one? No, investigation stage. What is the case about?
NDPS and the charges are section 22B.
Intermediate quantity. Your petitioner, can you tell us, your petitioner is in custody since when?
12/3/25.
12/3/25.
So,
Oh, 12/5.
almost 48 days.
Then we should keep because short date, I think. Short date we don't have, in fact. 13th, otherwise we don't have any. 13th. 13/5 we are listing.
Okay.
We are issue reminder, list on 13/5. Any request? Adjournment? Any request na lage, otherwise also CD is not available. Issue reminder, list on 13/5. Petition for withdrawal tomorrow.
May please, your lordship. I beg to mention item number 34 of hearing list. The criminal revision petition.
34.
34.
Yes.
This revision petition filed against the judgment and order dated 15/3/2013, which was passed by your lordship earlier.
Oh, acha.
While your lordship was additional session judge Mongol.
Okay.
That is
Okay, then appropriate bench.
appropriate.
should be 34 due. This is the matter before appropriate bench. Or any other bench without me. Okay, we're listing it.
May I please, your lordship? I have a criminal appeal with the first IA file, which has been lapsed for 7 days. The appeal is filed for lapse of 7 days, and for that I have filed a criminal IA number 264/2025
For condonation.
for condonation. For that, for a fixed date, I require your lordship 7th of this month, 7th May. Or 8 May, the fixed date, because I am coming from Lakhimpur, your honor. Lakhimpur.
Then in that case, 8.
Sorry,
Your matter may be listed on 8 of May.
May I please, your lordship?
We have paid for an anticipatory bill for tomorrow, my lord.
Tomorrow not
Only,
possible. No, not possible.
Only
Tomorrow
anticipatory
not
one
possible.
bill, my lord.
AB on 14th.
15th, my lord.
14th. Tomorrow.
Monday, my lord.
Monday is also not possible. Because what I have said is that frankly, I'm speaking that in all these days, up to, in fact, 14 is also, all our fixed matters are more than your, say, 30-35. Fixed matters are there apart from this. So that's why we are not in a position. 14th? Oh.
Obliged.
They released item 1.
May I please, your lordship?
Yes.
Lordship, here the petitioner was arrested on 28/2/2025, lordship.
28 to?
2025.
Yes.
Please, lordship. 2 months, 3 days, lordship.
2 months,
3 days.
3 days.
Here, lordship, the prime ground, lordship, on which I am seeking bail is, lordship, not furnishing of the ground of arrest. Lordship, may kindly come. This is another interesting case, lordship. Lordship, may kindly come to page number.
Just tell us one thing only. Grounds of arrest you have taken, it's all right. And otherwise also 2 months. It's a commercial quantity.
Yes, lordship.
Commercial
Commercial quantity.
Only matter to be, I want to ask you whether it is a case of caught red-handed or otherwise.
Yeah, lordship. From his possession.
From his position.
His possession. Why, lordship, I am referring to page number 20.
20?
Page number 26, lordship.
Yes, you are taking that ground.
Grounds of arrest, lordship. 26, lordship.
Mm.
Grounds of arrest. Sir, you are arrested in connection with above reference case as you have married a minor girl. Moreover, the minor girl has gave birth a child in the age of below 18 years, which revealed in the investigation. Hence, sufficient evidence has been found against you. Accordingly,
Where you are reading 25.
26, Lordship. Notice
Page
of
number-
information under section 47. My lord, got it?
Just a second, your thing is 47. In our case, it is in 27, page number 27. Anyway, 47 notice, na?
Yes, Lordship.
Hmm.
Grounds of arrest. My lord, got it?
Yes, yes, yes.
Third paragraph, Lordship.
Yes,
Grounds of
yes.
arrest. Sir, you are arrested in connection with the above reference case as you have married a minor girl. Moreover, the minor girl has gave birth a child in the age of below 18 years, which revealed in investigation. Hence, sufficient evidence.
What to do these things are, if you police
Yes,
officer does this perfunctory in fact, what is
And
this?
Lordship, I am having
Those
the
so
origin-
casually
Yeah.
repeated the grounds of a copy paste.
I'm having the original certified copies also, Lordship. This is the ground of arrest.
Yeah, I have also seen.
This is the ground of
Yes.
arrest, Lordship.
Otherwise, it's a case of NDPS.
Yes, Lordship. Otherwise, it is a case of NDPS.
Okay. Yes, Kaushik, what to submit, but I don't know what. Yes,
But
anything.
otherwise, it is, since it is a investigation stage, my lord. And request for the CD, my lord. But otherwise, commercial part. Otherwise, this is apparent, my lord. But
This is apparent.
Yes,
This is apparent. I'm having the original certified copies also, Lordship, and they cannot, Lordship, testify it also, Lordship. So, Lordship, clear violation is there, Lordship. Lordship, may kindly allow my.
They have first mentioned the PS case number and 22C.
Hmm.
Later, they have copy pasted.
Copy paste. Okay, heard Mr. M. Ahmed, the learned counsel for the petitioner, and also heard Mr. R. Kaushik, the learned additional PP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. It is submitted by Mr. Ahmed. The present accused petitioner got arrested in connection with this case on 28/2/2025, and he is behind the bar since last more than 2 months. Mr. He further submitted that the present accused petitioner is innocent and there was no recovery from his conscious position. Next paragraph, Mr. Ahmed further raised the issue that though the grounds of arrest was communicated in the notice issued to him under section 47 of the NDPS Act, the ground of arrest speaks about a case of rape with a minor girl, and who rape of a minor girl who gave birth a child under the below the age of 18, which is not at all relevant to the present case, and the case has been registered under section 22C/29 of the NDPS Act. Thus, accordingly, he submitted that the grounds of arrest, which was furnished to the accused petitioner, cannot be considered as a ground of arrest. Can be considered as a ground of arrest of the present case. Mr. Ahmed further submitted that, considering this aspect of the case for non-communication of the ground of arrest, non-communication of the proper ground of arrest, the accused petitioner is entitled to bail. Next paragraph. Mr. Kaushik, the learned additional PP, submitted in this regard that cases of commercial quantity and still under the stage of investigation. Accordingly, he submitted that CD may reveal the actual fact of the case. Next paragraph. Considering the submission made by learned counsel for both sides, especially considering the ground of arrest, which has been mentioned in the notice under section 47 of the NDPS, which is the NDPS, which is not at all relevant in the present case. I find that there is it is held that there is no communication of ground of arrest in connection with this case. Accordingly, bail. Baki olaban bihan kumar somar ani diba. Short submission kori diba. Okay, well granted. Will who's special?
Lordship, special just Shri Bhumi, Lordship.
Special just Considering the negligent conduct of the investigating officer. He do at a line more miladi verbs. Okay.
Highly applies.
Item 2.
My lord, in item number 2, lordship, the petitioner is in custody since last 84 days. Lordship. Admittedly, lordship, POCSO is there, lordship. My only prayer is that, lordship, because of recognized judgment, lordship, the presence of the informant is necessary. Lordship may issue notice and fixing a very short date. Today is 84 days, lordship. The charge sheet has not been.
So why have come so late? Dear notice, yeah, it is 5-6 days minimum. 1 week will be required for
Otherwise,
returning of the
lordship
notice also.
may appoint one amicus curiae, lordship. My prime ground would be, lordship, if in the meantime they submit the charge sheet, lordship, then, lordship, there would not be any ground, lordship. For that consideration on the lordship.
Now,
And
how
lordship,
can we fix now? It will has to go, we have to appoint an amicus unless the notice goes.
it is 84 days, lordship.
That's what I'm saying.
Lordship,
How
fix
can
it
we?
after 7 days? Lordship. Otherwise, lordship, my bail has been rejected by the learned court below, lordship. And in between, lordship, if I do not prefer any other bail, lordship, then I will not get the benefit of default bail also, lordship. That conception is there, lordship, unless and until, lordship, before filing the charge sheet, there is a pending bail application. I will not be entitled for default bail also.
My lord, let him take instruction, my lord, the steps today.
Yes,
We'll take instruction directly from the.
yes.
police.
That will be.
Heard Mr. M. Ahmed, the learned counsel for the petition. And also heard Mr. R. Kaushik, the learned additional PP, appearing on behalf of state respondent. Issue notice koyo bakili khona lagaiba to the respond number 2 to the Judicial Police Station, routed to the office of the registry and the public prosecutor. The Mr. Ahmed is also hereby asked to take steps within 2/3 days.
In the course of the day, lordship.
No, but during the course of the day. Mr. Kaushik is also the learned additional PP is hereby asked to take necessary instructions in regards to service of notice on the respond number 2. Please the matter accordingly when it can be listed.
On 6th or 7th, lordship.
6th. 6th.
Highly applies.
Item 3.
My lord, I have also taken similar ground, my lord, at page 30 annexure 4. And my lord, that contraband is alleged to be recovered from the vehicle, my lord, which I was driving, my lord.
Page 30.
Yes, my lord, annexure 4, I'm relying on my lord for arguing my bail, consideration of my bail application.
It is also perhaps.
Page
read-
30.
Yes, my lord, page 30, annexure 4. That is a notice which has been issued to me, my lord. And I was driving by vehicle, my lord, from there, my lord, contrabands were recovered, my lord, and the driver of the vehicle.
So otherwise recovery is from you.
Yes, yes, but otherwise it is it is from the vehicle only, my lord. Lordship was dealing with some
Other matters, that's
Yes,
what
ma'am.
I'm saying. It is a charge sheeted case? or
charge
no?
sheeted, my lord,
Charge sheeted
yes,
one.
ma'am. Charge sheeted case, and my lord, to my instruction matter is, my lord, in the month of May, it's posted for evidence, my lord, recording of first witness, my lord.
In the month of May.
Yes, my lord.
That's very cool. We should call for the case record, and in the meantime, some other judgments will also cover it. So we are fixing.
Lordship can post it some other day because Lordship is dealing with, my lord, some cases where this issue has cropped up,
Now,
my lord.
here you have also certified copies
have-
are with you.
Yes, my lord, it is with me, my lord.
And get your point. Because 13 up to 13, 14 will also.
I
So
understand, my lord, yes.
that's what.
So any convenient to this
Huh?
court only, my lord.
Either 1 week will do, then if there is any probability, then registry will fix your case
My lord,
after 1 week.
after
But we
15
not fix
my
it.
lord, 15 May, if possible, my lord, or 16 Lordship possible.
16.
16.
Call for this scan copy of the LCR along with the case tag. Okay.
Deeply obliged. me.
No, scan copy of the case record along with the CD. Beleg নহয়. আৰু fix it on 16.5.
I'm deeply obliged.
Or what to say? Request. Now, this 4 is there. You are appearing for 4. So there was a VC request, I think.
Yes, Your Lordship.
If the VC request is there, it will be taken up after the motion or other motion is over. Because the connection and NDPS will take some time. So after motion, it will maybe.
Obliged.
5,
May I please, Your Lordship? Your Lordship, 50 grams has been recovered with weight with the containers, Lordship. And already 33 days behind the bar, Lordship. Can be, if possible, Lordship.
Yes, Kaushik.
My lord, here it is from Mukal Mua, my lord. Did you maybe call for?
32 Lordship.
33 days he is in.
33 days and with container 50 grams, Lordship. It might come below, so 4 containers were there, Lordship.
Short date may be given convenient to this court.
Shortage is a very serious position for us, in fact. So you still 27 days a day.
27, but without the, I did not get the inventory, Lordship. In inventory, it might come below, Lordship, B also,
Maybe.
Lordship, because 4 containers are there, Lordship.
But wait, I don't know, 4 containers is a plastic this containers or
But
what?
Lordship, as per the file, Lordship, it's a Sada Tema, Lordship, that it will be in big in size, Lordship.
Sadhartema will
It will
definitely.
be not the original that container, Lordship, the plastic container, Lordship.
Equal, we don't. Copy. 1-4 will do, Mr. Muni, 1-4. Up to
Can you-
9-10, we have lots of
No,
matters.
that
in
I can understand, Lordship, that. Can it be on 12 or 12 is a holiday?
12 is a holiday, I think.
9 can be possible.
Okay, somehow we try.
Lordship, much of love. Lordship, one thing that item number 1, Lordship, we have seen, Lordship, that Lordship have considered the notice, Lordship, that some reason.
No, for the other reasons.
Yeah,
There
right.
are,
That I have heard
you will be
Lordship, yeah.
shocking the grounds of arrest.
Grounds of arrest.
So how negligently
No,
the
no.
agrees and that's so that
We
is why
thought
we
that Lordship
consider.
have come to some conclusion, Lordship, that is why. Lordship.
Pardon?
I thought that Lordship.
No,
have
no,
come to
no,
some
no.
conclusion.
Conclusion I have already there.
No,
We'll pass the order. There the 2-3 numbers of orders we have reserved. We'll
Lordship,
pass very
that is why-
shortly. Within
that
2-3
is why,
days we'll
Lordship.
pass. Already I have dictated all the orders.
Much obliged, Your Lord.
Okay.
Much obliged.
In fact, with you. City people.
item 6,
Regarding recovery of my lord, suspected Gaja, my lord, page 11, is the fire, my lord.
Page 11.
My lord, the below my lord commercial quantity and larger than my lord small quantity. Total 11 kg.
Your petitioner is behind the bar since when?
Since my lord, since 8 to 25.
8
So
to
my-
25.
Yes, so my lord statutory period
Then
already.
I will take instruction. Whether certain has been filed or not.
You're
But
taking instruction
Just now
Two
we
my
can
lord.
take.
At
just
two.
now?
After 1 week, after 1 hour, my.
No, at 2, my lord. We are in court.
At 2, there are some matters. At 2.
Or before raising this court.
My lord. At
Before 1, you can take
Before-
instructions.
before-
Okay, for time being, we are keeping it. Otherwise, your statutory period is already over.
7,
None appears on call for the petition. Please demand accordingly after 1 week.
item 8,
Yes.
My lord, item 8, and there are 2 other accused for bail application, 2 other accused who preferred bail application, and my lord was pleased to fix the matter on 7/5/25, my lord.
Are co-accused.
Yes, my lord. That bail application number is, my lord, 1260/2025,
1260.
/25, my lord.
It was fixed on 7.
7/5, my lord. So on that date, maybe take my
List the matter on 7/5/2025 along with the BA number 1260/2020.
DPO.
item 9,
On an
may I please, Your Lordship?
Yes.
Same matter on the grounds of arrest, Lordship. Lordship, 1 year, 4 months of incarceration.
From your position, otherwise for as per FIR from your position or subsequently you got arrested?
From the vehicle driven by.
Where
Yeah, I was
vehicle
there.
was driven by you.
Similar issue.
Lordship, charge sheeted matter, 3 number of witnesses has been examined. I have annexed the arrest memo, grounds are not there. The LCR may be called for them.
Otherwise she examined already.
Free
So it's going very good pace. And কিবা কেতিয়া পাৰিব 16 17 কিবা এটা 19 can it be on 19 okay 19
Short date would have been better.
let us see the result of the other matters then we case
Lordship.
you couldn't do a good argument yesterday.
Thank you
That's
so
very
much,
good.
Lordship.
19 thanks call for this case record along with the case time.
Highly obliged.
Item 10,
Lordship, please. Section 10. Bail has been rejected. My lord, I have been in custody since 25th of March. Procedurally, I think notice will have to go to the informal.
25th of
of
March.
I have completed 38 days till today. Mandatory is 60 days.
Hmm.
Which is expiring on 26th of May, I think. I'm only requesting it's. I know it's difficult to say for a short date that is convenient. This is Dispur Thana. Otherwise, informant is also in Guwahati only.
Informant is also in Guwahati.
Yes, my lord.
Section 10 POCSO. Section 10 POCSO.
Section 10 POCSO. Bail has been rejected.
Okay. Heard Mr. R.B. Fukan, the learned counsel for the petitioner, and also heard Mr. R.J. Burga, the learned additional PP, appearing on behalf of state respondent. Particularly human call for the case diary, and also issue notice to the respondent number 2 through jurisdiction police station routed to the office of the registry and the public prosecutor. We can somehow manage one date because one day you have to take, steps for issuing notice.
Yes.
So by today or by tomorrow, you can take steps.
I
so that
today
it may-
only I will take steps today.
Okay,
except my-
okay. And in the meantime, Mr. Burua will take some instruction regarding
be
the
doing-
service of notice. So in
extremely
that case, we may fix you on 6, 7, if you are filing a instruction to logo. On that day, we may appoint an amicus and then your matter will be heard. 15, 15th of episode দিব in first week of just he will take instructions. 8.
8.
Eight.
I'll be extremely grateful.
In the meantime, the learned additional PP, Mr. Bora will take instructions regarding the service of notice. He will take instruction regarding the service. And if the service is completed, yes, CD also. It is called for CD. If it comes, the CD comes, then it may be written up till next date.
I'm extremely grateful.
11,
Yes, Mr. For this petitioner is in custody for last 26 days, madam. It was alleged that he was following a car which is carrying the coal, madam. And when the car was intercepted, it was found that they are carrying some false document,
False document of full.
coal, madam, UA bills.
Or UA bills.
UA bills are forged. And allegation is that the petitioner is just following that particular vehicle. That is the content of the forwarding report. And on that account, he was subsequently arrested by. He was 26 days in the custody. Now, apart from that matter, only that is his allegation that he is following. Now, Lordship kindly see FIR at page 15.
Yes.
We acknowledge the receipt of your mail regarding the verification of the UA bill, and the same has been verified by the Deputy Commissioner of State, Next Dibrugarh Unit, Dibrugarh. Upon verification on the copy of the UA bill produced by the driver, it was produced by the driver. not by me, of the coal transportation vehicle intercepted by the Duliajan PS. The taxation department found that the road destination and the quantity mentioned in it does not match with the UA bill number generated dated 5/4/25 on the date of FIR. It shows that the transporters has forged the original document with the malified intention. So it was the driver who has produced that particular UA bill number, which alleged to be the forged one. Subsequently, I have been arrested, page 17. The grounds of arrest in the forwarding report. Point number 1, grounds of arrest. The accused Gunindra Sonwal, he is the driver, my lord, got red-handed while transporting the coal illegally, and the accused Biman Bora, he is the petitioner before your lordship class, found directly involved in escorting the loaded coal as well as the making and using the forged UA bill to use as a genuine with transporting the loaded coal. That is the allegation. Apart from my lordship, kindly see the notice that has been served to me. Page 25 is the notice to me, my lord, under 47. The grounds of arrest. Now, the 26 is the important page, 26 one, and it's a 5. Notice under 48 of the BNSS. Can be notice under 48, my lord, it has to be notice under 50. Now, here, there is no grounds of arrest, my lord. My lordship knows that with the Bihan Kumar, there are twofold requirements. First of the information to the arrested person. Also, grounded arrest has to be also communicated to the near and dear relative. But here, there is no grounds of arrest, my lord. This is the clear violation of the section 50A of the mandate, my lord. There is no grounds of arrest communicated to the family member, which is also a requirement under the Bihan Kumar case. Lordship knows it very well. That's the second part of the judgment, which is penned down by the Lordship Justice, Honorable Justice Koteshwar Singh. They specifically said that this is also mandatory requirement that the grounds of arrest must also be communicated to the family members, which has not been done in this particular case.
Yes. Otherwise, you admit that this coal were, the truck was loaded with coal, and that was, no. Now, you are following that truck.
As far as the allegation, I am following. Actually, I was not following. That is also I was subsequently picked up from someone else, my lord. Lordship kindly see the notice, page 26. They are saying in the forwarding report, I have been following the draft, whereas the page 26, the where from the person being held, that is blank.
May I take a lordship to page number 17, my lord. These are the forwarding report, my lord.
17.
17, my lord. My landed senior pen has already, my lord, read the, my lord, other ground, my lord, 1, 2, 3. I am just taking your lordship to, my lord. 3, my lord.
Ground number 3.
Accused Biman Bora also learned to be arrested earlier years ago in a similar offense, and the case record is being obtained, which reveals his repetition of commission of offense. These are the prima facie materials found, my lord.
I'm not on prima facie material, my lord.
Let me submit, my lord.
Page
My lord,
26.
Page number 25, my lord. This is the 47 notice, my lord. This is 15 CRPC notice of 3, my lord. 50 CRPC notice and now 47 BNSS, my lord. Here, my lord, this accused person, he was given the ground of arrest, my lord. Proceed, may kindly see, my lord. And regarding family members, my lord, so it is informed, my lord, that he has been arrested, my lord. Because ground of arrest is furnished to the accused person, my lord. And my lord, at the same time, my lord, it is also furnished to the family members, my lord.
No,
So
there's
why
no,
almost
there's no grounds of arrest in that particular memo. Where is that the grounds of arrest in the 26 information and the reasons for arrest and the grounds of arrest are two different things, my lord. That has been already been clarified. Grounds of arrest is related to that particular arrest, why he is being arrested. And intimation regarding arrest is totally different. But the judgment says it has to be the grounds of arrest also needs to be communicated to the family members. For
With
my
the second part.
second part, Lordship, can
I
you
have
take-
control.
I'm just reading-
Justice Koteswar said.
Yes, yes. That is says, my lord, the the issue of the requirement of the communication of the grounds of arrest to the person arrested as mandated Article 22(1) of the Constitution of India, which also been incorporated in the Prevention of Money Laundering Act under Section 19 thereof, has been sufficiently reiterated in the judgment. Constitutional mandate of informing the grounds of arrest to the person arrested in writing has been explained in the case of Pankaj Bansal Supra as to be meaningful to serve intended purpose which has been reiterated in Prabir Purakaste Sutra. This constitutional mandate has been incorporated in the statute under Section 50 of the CRPC, Section 40 of the 7 of the BNSS. It may also be noted, this is important, my lord, it may also be noted that the aforesaid provisions of requirement of communicating the grounds of arrest to be purposeful is also required to be communicated to the friends, relative, or such other person of the accused as may be disclosed or nominated by the accused person for the purpose of giving such information as provided under Section 50A of the CRPC. As may be noted, this is an addition to the requirement of provisions of Section 51 of the CRPC. So this is an addition, my lord. This is the mandate of the Supreme Court that not only the ground of arrest has to be communicated to the detainee, but also it has to be intimated to the family member. Grounds of arrest, my lord. It's not the information regarding arrest, my lord. Both are different, my lord. Information is different than the grounds of, here there is no grounds of arrest. Why he was picked up? It was simply that he was arrested. This is just an information that he was arrested. That's not the sufficient compliance of the Section 50. It vitiates, my lord. The arrest itself is vitiate as per the second part of the. The next page also lost the last line. The last part, I'm just reading. Hence, the requirement of the communicating the grounds of arrest in writing, not only to the arrested person, but also to the friends, relative, or other person as may be disclosed by nominated person, so as to make the mandate of Article 22(1) of the Constitution meaningful and effective, failing which such arrest may be rendered illegal. So it's rendered illegal, my lord. Itself, without the grounds of arrest communicating, it itself is illegal, my lord, as per the judgment. That's apparent on the face of the record. They cannot keep me for a second, my lord, as per the judgment.
Yes.
My humble submission, my lord, Gyan Kumar is not a ratio, my lord. Because, my lord, Gyan Kumar judgment, my lord, it is dealt with a person, my lord, even, my lord, who was not produced, my lord, within 24 hours, my lord. That is the, my lord, allegation in the Gyan Kumar case, my lord. He was, my lord, hospitalized, my lord, in, my lord, with handcuff, my lord. That is why, my lord, Gyan Kumar order was passed, my lord, and there is no such direction, my lord. As, my lord, the ratio laid down, my lord, in the Ernest Kumar and Sachin Kumar. Let me submit.
This is not a
My lord,
ratio,
if
my
I am
lord,
not allowed to submit, my lord, in between,
No,
yes, sir,
please
my lord.
submit.
Let me submit, my lord. After that, you will again submit a reply, my lord. My humble submission, my lord, lordship is well aware about the, my lord, Satendra Kumar Antil and my lord, the Ernest Kumar, my lord. There are specific directions, my lord. Even to the police officer also, my lord, that 41 notice has to be complied with, my lord. But where is there any findings in respect of Gyan Kumar case, my lord, then, my lord, the Pankaj Bansal and the other case, my lord. Prabir case, my lord. There is no such direction, my lord. So, my lord, this is not a ratio, my lord, as per my humble submission, my lord. And as far as this accused person is concerned, my lord, ground of arrest has been furnished to him, my lord.
Where is that grounds of arrest, my lord?
Even to the family members also, my lord.
Where is that, my lord? Lordship, can you read that?
Lordship may call for a case there. my lord.
Why case that?
This is in the documents, my lord. Yes,
This is
and
your, no, this is your document.
my lord.
No, no, my lord.
Certified copy.
This is a certified copy.
Certified.
This is your judicial magistrate document, my lord. This is not my
Judicial
document,
magistrate
my
is
lord.
not my
I am
lord.
sorry to say, my lord.
Judicial magistrate is not under my control, my lord.
This is a control of the court. This is the court document. And you are saying that this court document is not genuine. This is my document.
My humble submission, my lord, let the case.
Your
stand.
document, whatever may be the document, the prima facie satisfaction, if this is not the ratio, I'm surprised, man. I'm flabbergasted, my lord, by the submission of the learned PP that this is not ratio of the behind
My
judgment is not
submission-
ratio, my
My
lord.
submission may be recorded, my lord. I am
Your
submitting, my lord,
submission
this
may
is
be
not a ratio.
recorded that your submission may be recorded that this is not a ratio. I'll be very happy if this is recorded. The learned APP said this the Bihan Kumar judgment is not a ratio. I'll be very helpful that the Article 22 violation is interpreted that it is illegal if it's not complied with, and this is not a ratio as per the submission of the APP. Lordship can be recorded. It has to be recorded, my lord. It has to be recorded. It should
Yes,
go to the
record
everybody
it.
that his submission. Let them come with where is the grounds of arrest? This Supreme Court says it has to be grounds of arrest. Let them say there's any grounds of arrest. Anything regarding the grounds of arrest. This is just an intimation to the family members. Where is the grounds of arrest? It is totally different. Bihan Kumar says the grounds of arrest and the intimation is totally different. I must know, the family members must know why he was arrested so that they can take the legal recourses, my lord. That's the purpose of the whole interpretation of the Justice Kotesh saying. If he is going beyond that particular judgment, I have nothing to say. It's his own interpretation of the Bihan Kumar says and the subsequent judgment also. But as far as as on date, the Bihan Kumar exists and it says that it renders arrest is illegal, my lord.
My lord, if
There
my,
has to be, my lord.
my lord,
I
if
can
my
understand, my
learned senior friend submission is, my lord, correct, my lord. Then, my lord, the trial code also, my lord, where he was produced, my lord. Trial court has got ample power, my lord, to release the accused person on bail, my
So
lord.
now I have
Why
to
the
go.
trial, why the trial court has
So
not
that
released
means
on
he
bail,
said
my
that I have to go to the trial court.
No,
who has
he
not
was
applied.
produced, my lord. He was produced on the
Yes.
same day, my lord.
Yes,
Why the
but
trial court has not released, my lord? If Bihan Kumar
That
is a
is-
ratio,
that
my
is-
lord.
that
The
is-
trial court also ought to
that
release
is
him on
why
bail.
the Bihan Kumar has to go to the Supreme Court because of the trial court and the High Court rejected. That is why Bihan Kumar has to go to the Supreme Court. Why you have not objected? Why you have gone to the Supreme Court? Why the trial court has not released? Not following the Article 22. This is the submission, my lord. Just because trial court has not released me, so I don't have the right now before the High Court under the same provisions of law. I don't have the right in the Supreme Court to agitate. Whereas the Bihan Kumar said after the search sheet also, at any time, I can point out if there is an illegality. That is also there in the Bihan
Yes,
Kumar's case.
yes.
Even after the search sheet. Why? That means the arrest itself from the first day is rendered illegal, even after the search sheet. I can understand the objection by the objection has
My
to
lord,
be
by
something
humble submission, my lord, there is no illegality, my lord, as far as
that is
section 47
lordship
of
will
the, my
decide.
lord, 47 of the BNSS, my lord, and as well as, my lord, 48 notice, my lord, that is the information to his family member.
Yes, I agree. This is an information.
Submission may be recorded.
Yes, this is an information, but where is the grounds of arrest? Let him point it out.
So
If there is any grounds of arrest, I will withdraw my submission, my lord. If he can show it that the single grounds of arrest is incorporated in this, I will withdraw my.
My humble
There is a
let the
limit
case
to everything, my lord. There is fairness. Only for the sake of objection is not accepted, my lord. It is not a ratio, then what is the ratio of? Don't have the audacity to say that this is not a ratio, my lord.
Okay, I'll pass you out.
Obliged.
Assisted by you or MS.
Obliged.
Yes, please.
In 12,
Okay. Ground of arrest of যে গুলিয়া হলে বোঝা লাগছে।
May I please, your lordship?
Yes.
Lordship, my submission is also same, lordship. Lordship, charge-sheeted case, lordship, commercial case, earlier was rejected on by your lordship for petitioner number 3, lordship. 24/2/2025, lordship. So this time, I'm only in this ground, lordship. The ground of arrest was not there, lordship.
24 to 25, where is the rejection order?
Page 23, lordship.
Page 23.
It was preferred for petitioner number 3 only.
So when on the day of rejection only, 2 witnesses were already examined.
lordship.
So by that time, as per your information, how many witnesses examined?
Lordship, as per my instruction, lordship, I have no idea, lordship, because when I obtained the copy, lordship, till two was there, lordship.
So have you annexed this copy of the arrest memo and all?
I haven't.
Where it is?
Lordship, page 20, 21, and 22 for all 3 petitions.
Again, my lord, this is my lord, caught red-handed, my lord. So same lordship is my lord hearing already heard the matter, my lord.
That is
Regarding-
one difference just we are looking into. Sometimes it happens in the NDPS also on the basis of the statement of the co-accused, subsequently got arrested or something. But wherein the persons were caught red-handed, we're dealing with the matters since not 3 days actually. And yesterday there were some arguments also. So already 3 matters have been kept as a judgment where, orders were reserved. So I think that your matter should be posted.
Lordship, with regard to that, lordship, my submission is, lordship, that is version of the police, lordship, that I have got written.
No, we have to go by the version of the police initially now.
Lordship.
That's why if it is not your position, suppose,
That nothing has been found from my position.
that is your part, but the question is that from your vehicle, from your presence, that was recovered as per the FIR. It is not a case that you were subsequently got arrested. It's not the case. You were arrested with the contraband on the day itself. So that is the difference, what I'm saying. So in that case, caught red-handed, 2-3 arguments where I have already heard. Tomorrow also some arguments will be produced before, it will be before us in second also, tomorrow also. So your matter, in that case, your matter will be deferred for some days, maybe either 16, 17.
Lordship, in
There,
between-
there's judgment, let the judgments come out, then only it will be easier for you also to submit.
then, lordship,
We have
It is-
already discussed various judgments passed by the Honorable Apex Court in regards to caught red-handed, as well as the other issues are also there. Yesterday also there was a long argument, and tomorrow also some of the arguments have been fixed.
otherwise, lordship, the petitioner behind the bar since 413 days, lordship. Lordship, your lordship inclined to post the case, lordship, then lordship, in between, if required, scan copy may be called for.
Yes, we are calling it. And in that
Updated.
scan copy also, if as you have submitted, there may be some witnesses where from it may be heard that your position may not be from you, recovery may not be from you also.
Yes, in earlier rejection order, lordship,
Recovery is from him, my lord. There is the scissor list, page number 15, my lord. He recovered from his possession, my lord, and he has put his signature, my lord. Now he cannot deny, my lord.
when police
They must
asks to
cover.
put signature, lordship, who
No,
can
no,
deny?
this submission is not tenable, my lord. In every cases, my lord, it cannot be, it is not.
In the FIR, lordship, it is stated, lordship, as per FIR, lordship, from one lady, it was recovered. And in the seizure list, all 3 person was shown that from the position of all 3 petitioner, it is recovered. And earlier rejection order, it was submission for it was submitted by the earlier engaged counsel lordship that the two witnesses did not implicated the present petitioners. And moreover, there is a contradiction even regarding in the name of the train lordship, from which train they are traveling and the contraband was found.
Oh,
There
there's a
is-
contradiction.
Yes, there was that contradiction also, lordship. So all aspects, lordship.
Anyway, when it can be fixed. Today also, we have fixed one matter, similar matter on 19th, 19, similar matter. And in the meantime, we are calling for the scan copy of the case record and case type. Now see, till 15, 16, we are not in a position to fix any date, in fact. That's why I'm fixing it on 19,
Yes, lordship.
19.
Okay.
And in the meantime, we are calling for the case record and the case diary. Scan copy of the case record and case diary. I have already dictated the orders, in fact. By tomorrow, or may not be tomorrow, one matter will be heard. So by next week, the orders will be there.
Deeply understood.
Either
Please, lordship, NDPS matter, commercial matter, and there is usual my, so, yeah, grounds of arrest. Grounds of arrest.
yes, here also, you just tell us from recovery from your position as per FIR.
Yes, lordship.
As per FIR, recovery is from your position.
From my.
In that case, we are also fixing your case on 19.5. Since when your petition is in custody,
A short date may be given,
we don't have short date. That is the problem, in fact.
not it.
Uh,
Three may be called for. lordship.
it is a charge sheeted or not
Not
yet?
charge.
Not yet charge sheeted. Since when your petition is in custody?
And 4.5 months.
4.5 months, 6 months is there, na? So, okay, then we are fixing it on 19.5. We are calling for the case diary, take the grounds of arrest, everything on that day. Because court and matters, we are just putting some defer on 19.5. CD call for 19.5.
Obliged.
14,
Yes,
Lordship, item number 14.
yes.
Same lordship, what lordship has observed there. They
But
recovered
there
from
is
me,
two observation by us. One is court handed and other one is not court
Recovered
handed.
from me.
Whereas
from me,
you also court handed,
100%.
It is a
21
certificate.
100%. Okay.
And 15 also the same your lordship. This is the second.
Here, is a charge sheeted one or not
Charge
yet?
sheeted
Charge sheeted one. Case has already been charge sheeted.
In this 14 case, 14 it is not been substituted.
We have annexed the copy of.
Oh, yes, yes. Partly substitute, in this case, yes, this honorable court has already granted bail or to consider the case before the trial court by this honorable court. Thereafter, not obtaining the FSL report, that is only one ground. So my humble prayer is that update,
Yes,
Uh,
obviously, updated case diary
ah.
will be called.
that is my humble suggestion.
Can his case also fixed on 19th? Can it be possible? You want 19 or 20?
More than I have possible.
Because you have two cases, na?
Yes, yes. Maybe
In 14, most probably, if case is already charge sheeted, Mr. Reddy,
14 substituted.
charge sheeted. Tite hali likho. 14 article had Dr. B.R. Gogoi, Dilan counsel for the petitioner, and also had Mr. D.P. Goswami, so and so. Is scan copy of the case report along with the case diary being called for with the up-to-date status report.
Lots,
Then is both the matters we are going to fix on 25,
lots.
25, 205. And other one is also charge sheeted or
No.
not yet?
Not.
Not charge sheeted. This 15th apani call corridor case diary to on 15th. Item number?
Same 25. If lordship permit me to. Same
No,
fix of 25.
25, we are calling it
Oh,
case diary.
case diary.
Case diary. Here, other one, we are calling this scan copy of the case record along with the case diary, and this one, we are calling for the case diary only. Both the matters, we are going to fix 25. 205.
I'm deeply obliged.
Okay.
16,
Motion
please,
has been
Lord.
asked. Yes, that he too কৰিব লাগে। তেখেত মানুহজন আছে নে ইয়াত? No, he is there only. He is there only. After this matter, we are going to connect DBC.
Maybe. Your Lordship.
Yes,
It's
yes,
a 482 petition, Lordship.
yes.
The petitioner has not been named as an accused in the FIR, Lordship. The only relevant portion, Lordship, FIR is a long FIR.
Hmm.
So I'm reading from page 19, Lordship, the operative portion. The brief, Lordship, page 19,
Yes.
second paragraph.
Yes.
The brief of the case is that on 18/4/25, complainant SIP Rontu Hazarika lost the written FIR to the effect that on 17 April 25. At about 6:35 p.m., a credible intelligence was received that in the shop of one Putlu Rao at Bokahola Bagan near Shiva Temple in Titabar PS, the betting is going on in IPL. And that Putlu Rao collects money from common people for betting on IPL, and that he is working as a mere agent of a kingpin. SIP Rontu Hazarika and WSIP Nirupama Das, WHG Niru Hazarika and Evelvista proceeded to Bokahola Bagan. After arriving on the spot, found Putlu Rao, son of Jogeshwar Rao, village Bokahola Bagan, PS Titabar, district Jorat, was engaged in game and betting with his mobile phone. His phone was checked and it was found to be containing game and betting data pertaining to Indian Premier League betting money gambled by people and collected by him as an agent. The photos of the betting of IPL contained in the mobile of Putlu Rao, son of Jogeshwar Rao, attached below. Model number Iman, Android mobile handset by IMA Iman. Lordship. Now, next paragraph, next page, Lordship, page 20. On spot interrogation, Putlu Rao stated that one Sanjeev Kalwar and Dilip Kalwar of Titabar town have been running the game and betting activities of IPL in Titabar area with help of deploying agents and also engaging some workers of his furniture industries. He further stated that Sanjeev Kalwar has a history of doing illicit betting business on IPL and that he is a mere agent of him. Lordship, the petitioner is Dilip Kalwar. The only time the name of Dilip Kalwar has been mentioned is in this line. Lordship. In the very next line, he has stated that it is Sanjeev Kalwar who runs the business. And Lordship, police have also not found anything from his possession, nor have they arraigned him as an accused, Lordship. Okay, they will call for Lordship. Interim may be granted, Lordship. It's an AV petition. His name is not there as an accused, Lordship. Only on one slight mention, Lordship. Nothing else is there.
But the asset person is stating that
No, Lordship. Only one, Putlu Rao. Only one time. On the very next line, he stated it was Sanjeev Kalwar, not Dilip Kalwar. Both of them are brothers, Lordship. So maybe he has taken the name just casually in a casual manner, Lordship.
I take a case there only.
Except this single line, Lordship, no mention of Dilip Kalwar is there, either in the FIR or the forwarding or anywhere.
But this is the FIR or forwarding.
This is the contents of the FIR, Lordship. Forwarding is in the page, from page 32, Lordship. Same thing, Lord. Same, only the photos of phones are there, Lord. The difference is there. And even Lordship, other none of them have mentioned Dilip Kalwar.
You also work in the furniture house.
No, Lordship. I am not a worker of the furniture house. The Sanjeev Kalwar was my brother, Lordship. He is my brother. We live in adjacent houses, Lordship.
They should have
The
in the connection of other case.
Lordship, that is Sanjeev Kalwar. Sanjeev Kalwar. I am not praying for Sanjeev Kalwar, Lordship. I am praying for Dilip Kalwar. Sanjeev Kalwar is arrested, Lordship. I am not talking about him, Lordship. He has his furniture business. I work in a private company, Lordship. I have no relation with these matters. Earlier also, no allegation is there against me, Lord.
Heard Mr. S. K. Das. Heard Mr. K. Das, still on the counsel for the petition. And also heard Mr. D.B. Goswami, the learned additional PP, appearing on behalf of state respondent. It is an application under section so and so in connection with so and so. It is it is submitted by Mr. Das, the learned counsel for the petition, that the present petitioner is innocent and he is no way involved in the alleged offense. He is not an FIR named accused except a single line has been mentioned in the FIR, but subsequently there is no mention or involvement of the present petitioner in the said offense. He does not work in the furniture house of his brother Sanjeev Kalwar and works in a private company and not at all associated with the said offense. He further, however, he submitted that he is ready and willing to cooperate the IU in further investigation of this case if he is granted with the privilege of interim pre-arrest bail. He insist for against diary and it will be discussed. Okay, you'll be under interim protection. Till the receipt of the case diary, cooperate with the investigation and
23rd May.
2-3.
23rd.
CDB.
DP of the court.
Item 4 through VC.
May I please, your ladyship?
Yes.
Your ladyship, it is a regular bail application, the special case number 72 of 2024, under section 20B to C 2529 of the NDPS 1985. I respectfully draw your ladyship's attention to this matter. Your ladyship, in this matter, the petitioner is in custody since 22nd of June 2024, and it has already been 10 months, your ladyship.
22nd
Moreover,
of June.
yes, your ladyship.
Yes.
And your ladyship, this matter is also squarely covered by the Vihan Kumar versus State of Haryana judgment. Your ladyship, because no grounds of arrest were communicated in this matter to the petitioner at the time of arrest, which is a requirement under section 52(1) of the NDPS Act, your ladyship. And also, your ladyship, the petitioner is of clean character, and prior to this case, there was no criminal antecedent.
Do you have annexed only the arrest memo? Whether there is any 47, etc., we have annexed? No.
No, no, your ladyship, the arrest memo is in Annexure 2. It's page 26, if you please.
Only the arrest memo we have annexed.
Yes, your ladyship.
47, 48, do you have annexed? No.
No.
We need the 47 and 48 also. Arrest memo is okay. There is no ground of arrest, as you have seen. But the question it is, we don't know, we are not in a position to say whether the 47 and 48, which was issued to the petitioner, is there also the grounds of arrest were not there. That is the position. So now, case is charge sheeted one or not yet?
Yes, charge sheeted.
Case is charge sheeted. So what we can do, we can call for the scan copy of this case record along with the case diary. In the meantime, you can also file the certified copy of the 47 and 48 if you can obtain by this time. Otherwise, we are fixing it on because, and one more thing, this as per allegation, the contraband was recovered from your possession as per allegation. Or
I was the driver of the truck.
so if you are the driver of the truck, the contraband was recovered from your possession. You may not be involved in the case, so we are not on that. And that apart, the grounds of arrest is one of the ground, obviously. But the question is that we are calling for the case record and case diary, which definitely reveal the 40, then definitely it will be there, the 47 and 47, it will be there. In the meantime, you can also file your certified copies. Okay.
Obliged.
We are fixing it someday. You are MS Vaishali Ghosh?
Vaishali Ghosh Bhattacharya, yes.
Yes. Okay. Heard MS Vaishali Ghosh Bhattacharya, the counsel for the petitioner, and also heard Mr. DP Goswami, so and so, Baki man likhibo na lage. Call for the scan copy of the case record along with the case diary and the present status of the case. Registry will do the needful. In the meantime, the petitioner is at liberty to file the certified copy of the 47 and 48 notice, BNSS notice, as the grounds of as they have already taken the ground of non-mentioning the ground of arrest in the notices. List accordingly. Is there any convenient date, or were you going to submit to VC, or you want to before this court physically?
Your ladyship, I would be submitting to VC, I believe.
To VC. When it can be? 21?
21.
20 or 2023? 23rd of May will be preferable, 23rd of.
Yes, yes, your ladyship.
Okay, sure, 23rd of May.
Obliged, your ladyship.
23rd. Okay,
For bail hearing, item 17.
No, PG Lordship. Lordship, charge sheeted matter, your Lordship.
you have received this scan copy here?
Yes, please, yes.
The section 6 of the POCSO Act is there, your Lordship. I
Yes,
think that's one number 2
Yes,
is also.
she has already
there,
done.
Your Lordship. Here, your Lordship, the petitioner has been arrested on 5/6/2024, 11 months behind the bar.
5/6/24.
Here, your Lordship, there are 10 witnesses as per the charge sheet,
10 witnesses.
Lordship. But Lordship, as per my information, as per the instruction, your Lordship, only one witness has been examined. Victim yet to be examined, your Lordship, in this case. And we have filed bail petition before the trial court also. On that ground, your Lordship, that victim has not been examined till date, your Lordship. My bail petition has been rejected, your Lordship, on that ground only. Now, your Lordship, the victim has been properly served. Someone has been served, your Lordship. They somehow, the informant and victim appear before the trial court, but they filed adjournment petition. And that had been adjourned, your Lordship, in various dates, your Lordship. Your Lordship produce, since your Lordship, because here, your
Every day
Lordship,
they appeared and they took adjournment.
they took adjournment, your Lordship, in some dates, your Lordship, not every day, your Lordship. Again, someone has been issued, your Lordship. In this way, the case is going on, your Lordship. In this way, your Lordship. Already in this way, in this Lordship, the accused, the petitioner behind the bar more than 11 months, your Lordship. So my humble prayer, your Lordship, not too much to submit in this case, your Lordship. I'm on the merit of the case, your Lordship. And because only one informant has been examined already till date, your Lordship. That is my submission, your Lordship. Not much, your
But
Lordship.
scan copy is not up to date. Here, Lordship, only next date of up to 11/3/25.
That is very much clear from the online, your Lordship. I have obtained this thing also.
After 11/3 also you have? No, we
Because
are
it was
updated
again
till
9
11.
May. Yes, I have everything.
What is the next date? After 11/3?
9 May.
9th of May.
9th of May, your Lordship.
So on 11/3, no witnesses were examined.
No, none. Till date, none, your Lordship.
8 PW.
It was
She's saying 10 PWs, 8 or 10?
8 Lordship, sorry. 8 PW, sorry, Lordship. Hmm. 10. Charge sheet 10, your Lordship. My charge sheet, I have annexed my charge at page number 14, your Lordship. Page number.
Yes, any other submission?
Lordship. The statement of the 183 statement of the victim of the included the petitioner and also injury purpose there. In the medical report, Lordship, I have like the medical report, Lordship. There is a evidence of injury which is described in the genital examination, Lordship. And there is rubbing against the private part, her private part, Lordship. So at this stage of trial, Lordship, the petitioner is included by the victim also, and sufficient materials are there to it should not be released on bail, Lordship, at this stage.
Yes, Mr.
Lordship, may for a moment peruse page number 45, Lordship. There is a last rejection order. After this, I think there is no application, bail application.
45.
Bail application that was rejected, Lordship.
That was rejected on which date? 21?
25, Lordship. 21st of Jan.
But she already, I mean, as far on that day, victim was not examined. But thereafter, she has you have already obtained the certified, I mean, the online.
Yes, yes,
Orders.
yes.
So from where it is seen that most probably after 2101 also, victim is not being examined.
Lordship.
And the certified, I mean, the scan copy of the record also says that it is up to date on till March, but thereafter also no examination is there. Admittedly. Yes.
Lordship
And
may-
other submissions?
Lordship, maybe it may be like, she may be examined, Lordship, because it's a minor, Lordship. So my prayer is that a bail application at this stage may be rejected till she's examined, Lordship.
Cases registered under 6 POCSO?
Under section 6 and
376.
366
and
A
of the
also.
IPC, your lordship.
366A, 376-2 and section 6 POCSO.
If your lordship kindly come to page number 17.
1
That is 17, your lordship.
70.
17,
Oh, sorry, 17. Huh.
That is 1724 charges has been framed against me, your lordship. That is the first day charges has been framed against me, your lordship. Again, 11/7/2024, someone to the victim returned duly served. That is at page number you will find, your lordship, 18, your lordship. Relevant portion I'm reading, your lordship, 11/7, your lordship. That is third line, your lordship. Order of 11/7/2024. Someone to the victim returned duly served, seen the report. Someone to the informant PW's Anwara Begum, Abdul Salam, Imrana Khatun, not properly served, seen the report. Next page, your lordship. Informant victim as well as PW's, namely Abdul Salam, Imrana Khatun are absent. White petition number 855/24, which is produced hard and condoned for issue phrase someone to the informant and victim. First, your lordship. Again, if your lordship kindly come to page number 20, your lordship. Someone has been issued fresh.
She has not appeared.
She has not appeared at any instance, your lordship. Someone has been on daily basis, your lordship. Someone has been issued, your lordship. Somehow, in some way, your lordship, she appeared in 2 or 3 days. She take adjournment, and it was allowed, your lordship. Not the merit of the case, because 11 months already been behind the bar, your lordship. Any condition, your lordship, any condition. My humble prayer, your lordship.
But in the charge sheet, Lordship, he has been shown as an absconder and he was arrested on 5/6/2024
Yes, yes, that is admitted, your
after the issuance of non-bailable warrant. So he was an absconder, Lordship,
Yes,
and so
Lordship.
there is even in the like bail rejection order, Lordship, it's been mentioned that the facts of the case indicate that there is likelihood of tampering of evidence and he may dissuade the remaining witnesses from coming to court or telling the truth during trial. So there is this apprehension also, Lordship.
For that, your lordship may kindly impose any condition.
Mere like
strict
law
condition, your lordship.
incarceration may not be the only ground, Lordship, why bail should be granted, in my humble opinion.
Heard Ms. G. Bora, the learned counsel for the petition. And also heard Mr. D.B. Goswami, the learned additional PP, appearing on behalf of state respondent. And MSD Sekia, the learned amicus, appearing on behalf of the respondent number 2. This is an application under section so and so in connection with so and so. Case diary is case scan copy of the case record has already been received. Where is the same? Next plan, it is submitted by MS Bora that the present accused petitioner is innocent and he has been falsely implicated in this case. He got arrested in connection with this case on 5/6/2024 and since then, since 11 months, he is in custody. The charge of the case charge was framed 1/7/2024, and since then, the case has been fixed for evidence. But till date, only one witness, that is the informant, is examined by the prosecution out of 10 cited witnesses. She further submitted that in 2-3 occasions, the summons were also duly served on the informant of the victim of this case, but they took adjournment and did not appear before the court to adduce their evidence. And thus, the case is still at the stage of evidence. And even after long 11 months custody of the present petitioner, only one witness could be examined by the prosecution. And hence it will take a reasonable time for completion of the trial and completion of the trial. She further submitted that the accused being a permanent resident of his address locality, he will appear before the Rani trial court below on each and every date to be fixed by the court. Next prayer. Mr. Kusami, the learned edition PP submitted in this regard that the informant, the victim was a minor at the relevant time of incident. And there is sufficient incrimination in her statement made under section 164 CRPC. More so, the medical reports also reveals the injuries sustained by the minor victim. Accordingly, he submitted that, and accordingly, he raised objection and submitted that it is not a fit case to allow the accused to go on bail at this stage. Next para, MS Saikya, the learned amicus curiae for the respondent number 2 submitted that the girl was admittedly minor at the relevant time of incident, and from the rejection order of the learned special judge, it also reveals that the accused was shown as an absconder in the charge sheet, and subsequently, on the strength of NBWA, he was arrested on 5/6/2024. So, considering the conduct of the accused petitioner, his earlier bail application was rejected as considering expressing the view that probability of hampering or tampering with the evidences, it cannot be denied. She accordingly raised objection and submitted that there is every probability of influencing the witnesses, and hence the bail should not be granted at this stage, only considering the long incarceration. Next product. Considering the submission made by learning counsel for both sides, I have also prepared this scan copy of the case record, and it is seen that some incriminating materials have been brought by the victim in her statement recorded under section 164 CRPC. It is also, however, it is a fact that till date, the prosecution could examine only one witnesses out of 8 numbers of witnesses, and the victim is yet to be examined by the prosecution. Further, from the orders also reveals that the victim and the informant also took adjournment in some occasion, and for which the fresh summon has to be issued against the victim. However, considering the materials in the case diary, the materials in the case record, especially the medical report as well as the statement of the victim, I find that victim, it's the probability of influencing the minor victim also cannot be denied at this stage, and hence I do not find it a fit case to enlarge the accused petitioner on bail at this stage without recording the statement of vital witnesses, including especially the victim. In view of this, petition is acquitted. Your petition stands rejected.
Lordship, just Lordship, for a moment, may see page number 15, Lordship. Yes, it's mentioned that there are 10 witnesses in the charge sheet, Lordship.
Why you are confusing 10, 15, 10, 8, 15, 8 and 10, 8 and 10? Para 15.
This page was not given.
Yes, 10 witnesses. 10 witness quoted.
And one more thing, Lordship, page number 4, Lordship. I don't know, Lordship, here it is written that paragraph number 6, Lordship.
Page number?
4, Lordship.
4.
Paragraph 6, Lordship. It's written that charges were framed up 11/7/2024.
So maybe typographical error, maybe.
So 1/7.
And the next paragraph, Lordship, it's mentioned that like PW, the informant of the aforesaid case, as well as the father of the victim, examined in camera and cross-examined by the defense counsel. And then, Lordship, it's mentioned that don't frequent occasions the learned court below issued summons to the victim, and despite of being received said summons, Victim never appeared, and only PW3, namely Imara Khatun, appeared.
Yes, Imran
No,
Khatun
no.
appeared, informal
PW
appearance.
Just there is a confusion, I think. The PW3, she is not PW3. In fact, witness number 3 most probably in the charge sheet. If I'm not wrong, let me see the charge sheet.
Because there was a confusion, Lordship, I brought in this fact before, Lordship.
1, 2. But 1, 2, 3. 3 is not Minada.
2 is Imran, Your Lordship.
Huh?
2 is Imran.
2 is Imam.
2 is Imran, Your Lordship.
So you made some contradictory statement in the, yes.
The draft
Go through the case record and case and then you make submission. Because these are the impeaching statement. Oh,
Still, Lordship. Deeply obliged, Lordship.
okay.
Here,
He's going to be evaluated from him. He needs to bring the.
not received it.
And
And,
it's received, I think, not received.
in the cause list, it is not shown. And my lord,
Scan copy now,
I think yes.
we have received, somehow it remained, probably it was not.
And my response number 2.
Evidences are going to scan copy na asali kita na. Only evidences. No, whatever, I got scan copy to asali. It is only for evidence. Huh?
Evidence and then.
Or this is evidence was subsequently given.
Lord, here, 2 person has been, the informant as well as the victim examined. Victim partly
Now,
examined.
who is representing the victim?
Notice was served.
Now you have to, someone has to represent.
One, well, because we got information, my client informed me that they never come here. My client informed me that she never come here. She will not appear.
She will not appear.
Yes, madam. It is informed.
From where you're saying that it is
No,
already.
my client informed me.
No. Client information, the notice has already been served. Have you taken instructions in that regard? As per you, notice is served.
We have taken notice in 2 times.
No, steps
so
you have
two
taken,
officials.
it's not disputed. Have you
But they informed me that they have got information already.
taken instructions then?
If not, they let the amicus curiae
After some time.
After some time. Just let us take his instructions, then immediately we'll appoint one amicus also. Just for time being.
90.
May I please, your lordship? My lord, here in this case, petitioner is behind the bar since last 140 days, lordship. I have already taken step for service of notice upon the response number 2. Service is awaited.
You have taken steps when? On 4/4.
On
4/4, most probably the office of the PP received the summons. No?
yes, 3/4 lordship, I have taken step. Service is
It
awaited
is still awaited then.
29 for
Your petitioner is behind the bar since when?
140 days, lordship.
140 days.
So maintain.
If we can take instruction, then we can keep it for time being. Then if the service is already, the notice is already been served, then immediately today itself, we are going to appoint the amicus also. For time being, we are keeping. For the other earlier case also, same thing.
Yes, after something.
Oh.
Problem.
Time being both will problem हो जाएगा. Now see where there is one problem in fact. Though we are keeping this timing for timing, to try to make it before 1 because at 2 the Arunachal matter is there. So other matters will be adjourned maybe. That's right.
20.
20 instruction from the IO lordship service completed.
service completed.
But he won't come, my lord. Actually, my the father and his the husband and his the father is inside, my lord, because my lord, it's a child marriage case.
Oh,
And my lord, the case that he but my lord, the record maybe.
TD no scan record. Scan record we have already received.
My lord, I have submitted, my lord, that 47, 48, my lord, was not complied with. And 52 days in custody, my lord. It may be in the record, my lord, 47 in the record, 47, 48 notice, my lord, I know, my lord, 52 days in custody, my lord, child married at some time, my lord, now husband and his father is inside, my lord, for 52 days.
You have annexed here the
No, but
notices.
it is in the record, my lord. 47.
Your petitioner's name is?
My lord, two petitioners, my lord.
One is Sadikul.
Sadiqul, my lord, and one is Sikot Ali. Sikot Ali is the father, Sadiqul is the son, my lord.
So victim is the wife or
Wife, my lord.
informant.
Informant, my lord. It was the child she has stated, it was child marriage, my lord.
No, respondent number 2, who is he? Respondent number
Wife.
wife of one.
Wife of petition number maybe one.
Our wife.
No, it is, I'm mark. Sorry for pardon.
Oh,
Oh, Sadiqul Islam. Sorry for
she is the wife of whom?
wife of my lord, the petitioner number 1. Sadiqul Islam.
So otherwise she is the informant or victim?
Informant plus victim, my lord.
She is the informant also.
Informant also, my lord.
Why she lost the FIR if she is happily residing?
Yes, my lord. Page 9 is the. No, she was not happily married, my lord. As per the allegation, but it was a child marriage. The Child Marriage Act is also there. Page 9. My lord, is the FIR. At the time of marriage, she alleged that she was 17 years old.
So she brought some allegation against husband and
Now she is
main allegation is dowry.
dowry. And my 52 days in custody, lordship, and 47, 48 lordship might have seen, my lord. It has not been complied with. So my further custody may not be required, your lordship.
Yes, Gusame, any submission?
As per her statement, one it makes you implicate the petitioner lodge. The demanded dowry and is just taken into and rap against her forcefully raped, and therefore he promised to marry. And later if the male child was born, later, and she was beaten up by taking.
But subsequently there was marriage or there was no marriage?
Marriage. All the implications are there.
Any condition, my lord, and 48, especially considering the 47 and 48.
Heard Mr. S.M. Abdullah P, the learned counsel for the petitioner, and also heard Mr. D.P. Goswami, the learned additional PP, appearing on behalf of said respondent. This is an application under section so and so in connection with so and so. Scanned copy of the case record has already been received. There is the same first off. It is also informed by the learned additional PP, Mr. Goswami, that the notice has already been served with the respondent number 2. Respondent number 2. In that context, Mr. Abdullah submitted that the informant come victim of this case is the wife of the petitioner number 1, and she may not appear before the court. First. Mr. Abdullah P further submitted that the present 2 petitioners, petitioner number 1 is the husband of the victim, and the petitioner number 2 is the father-in-law of the victim come informant. It is a case of allegation of child marriage against the petitioner number 1 and 2. However, petition number 1 and 2. Full stop. Mr. Abdullah further submitted that apart from the other grounds, he took the grounds of non-furnishing of the grounds of arrest to the present accused petitioners while issuing notice under section 47/48 BNSS, which is mandatorily required to be served and which is in violation of Article 21/22 subsection sub 1 of the Constitution of India. In that context, he also cited Bihan Kumar and so forth. Next, Mr. Goswami, the learned edition PP submitted in this regard that there are sufficient incremental matrix in the statement made by the victim under section 183 CRPC. And as per allegation, she was a minor at the relevant time of incident when she was forcefully raped and married by the petitioner number 1. Mr. Goswami accordingly raised objection and submitted that it is not a fit case wherein the accused persons can be released on bail at this stage. 51 days means how it is already charge sheeted case.
No.
Then why this has come? Why CD is not there?
He was, so we have called for a city twice, 23/4/25 also we have intimated, but house scan copy was called at least. But it already reflects CD was called for.
Can I scan copy? Huh? Oh,
Perform scan copy.
there was just some mistake actually. There
But
was
the
some
CD in the form of the scan copy, man.
Yeah, otherwise the materials are there, I think. I have gone through also. Scan copy of the case record along with the case diary লিখি দিব বাকি ground of arrest or non-mentioning করে mail করে দিব Okay, we'll add that with me. To whose satisfaction?
Special just Sonipur test for.
Special just Sonipur test for.
I'm deeply obliged, Your Lordship.
Okay, 22. Civil to descend. 22 by scan copy is there? I don't know. 20? Charge দিব পাৰিছে না নাই? No, 25 মাটি দিও 25 মাটি দিও
Upgraded items release.
M. Khan is not there. I think.
Regarding personal affair, he was in fact present, my officer was present in the last occasion also, my lord. But again, my lord, in the order, my lord, I have seen the order, my lord. Order date 4/4/2024, my lord, 25, my lord.
Yes.
Again, he was directed to appear.
On the last occasion also you have appeared. What's your good name? Huh? Come forward. Arnab? Karnab Patwari. So why the court has to issue notice for your personal so cause? Oblige the court orders. What is this?
I was on leave, so I could not send the CD of that.
You were on leave on for what ground? Medical. Wedding. So it's a good ground for leave. It's okay. But why? For your leave, is there any provision for sending the record by some other also? Because if a person goes or if an officer goes for leave for say around 1 month or 2 months, in that case the petitioner, I mean the other one can suffer effect.
My full summation, my lord, when the person goes for leave for long period, my lord,
Ah.
suppose 10 days, 15 days or my lord, they handed over that case right to my lord, the officer in charge, my lord.
Where are you following that procedure? Because you may be leave for other reason also, it may be leave may be extended up to 5 months or 6 months also. In that case, whether the entire proceeding will be stopped or by if the in case when the court call for the case diary. It seems that there are some observation in the by the court that for which your personal appearance was called for, in fact.
he was leave for certain period. And prior to that and after that, so many occasions these honorable were directed to please the city.
So is there any mention about his presence on the last occasion?
Yes.
On 4/4?
Yes.
No, in order.
Yes, Lordship, on the last occasion also the direction of prayer.
Since Iman deputed. So your statement is yet to be recorded. Right.
Subsequently recorded after that order.
After this order.
Yes.
Now you have recorded. How many petitioners were there?
Yeah, two petitioner lordship during the pendency of this petitioner lordship, petitioner number 1 already arrested, and he is subsequently released on bail.
So now the petition number 2 petition, cases exist
Yes,
here.
yes.
So now updated case diary is there.
It's a matter and petitioner number 2, he appeared before the investigating officer's statement recorded, madam, and there is in fact there is a note of the investigating officer also, madam. There is no such materials against the petitioner number 2. There is Mojibur Rahman.
So what is the procedure in fact? Do you know about the procedure? That if a person or if an officer goes for a leave for a sufficient, for a reasonable period, maybe 2, 3 months or 4 months, then what is the procedure? So whether you have handed over in that case? You have not. Why? You can ask for the senior officer also, that whether CD should be handed over to someone. Because for your leave, definitely you have a marriage, you have to take leave. That is not disputed. But the question is that you have to hand it over. Otherwise, the person, now he is on interim, was on interim, I think.
Before my statement.
Pardon?
My interim was granted after perusing the case diary. That was-
Whatever, but he is in interim. Suppose in a case, he may not be on the interim also. There may be apprehension of arrest or even an arrested accused person. There may be an arrested accused person also. In that case, what will you do? Henceforth, don't do all these things. Whenever the court calls for a case diary, there may be in 1 occasion or 2 occasion may not be possible for the officer to send the case diary. That I understood. That is also, we are also cooperating in that case. But it's not the fact here from the order itself. It seems that on 1, 2, 3, 4, say about 5 occasions you have failed to produce the case diary. It was pending since 8/1, I think, and 8/1, 21/2, 12/3, 26/3, for 4 days. So it's not a case that 1, 2 days were there. Yes, then otherwise you have cooperated in the case diary. You are on basically on the petitioner number 2.
2.
1 is already got arrested. Heard Mr. M. Khan, the learned counsel for the petitioner. And also heard Mr. R.J. Burva, the learned additional PP, appearing on behalf of state respondent. And the IO of this case, Mr. Keith, what is your good name again? Say Karnap Patwari also appeared personally in pursuant to order of dated 4/4/2025 by Justice Court. Updated case diary is also produced and it is submitted by Mr. Patwari, the IO, that he was on leave due to his marriage ceremony, but he apologized and submitted that he did not hand over the case diary to other officers during his leave. The officer was accordingly directed not to commit or not to repeat this similar mistake in further in his career. in further. Next para. Mr. Khan, the learned additional PP submitted in this regard that, learned counsel for the petitioner submitted in this regard that the petitioner number 1 is already got arrested in connection with this case during the pendency of the petition, and the present petitioner is pending only against petitioner number 2. Full stop. After obtaining the order of pre-arrest bail, he already appeared before the IO in various occasions, but due to absence of the IO, his statement could not be recorded, and subsequently, his statement is recorded after the order of 4/4/2025. He is still ready and willing to cooperate the IO in further investigation of this case if he is granted with the privilege of pre-arrest bail. Next para, Mr. Goswami, the learned additional PP submitted in this regard that the petitioner already cooperated in the investigation of this case, and his statement is also recorded by the IO. More so, there from the note of the IO, it is seen that there is no such allegations against the present accused petitioner, and hence his further custodial interrogation may not be required.
No, he's not in custody.
No, his custodial interrogation. Pardon of the custodial interrogation may not be required for the interest of the investigation. Next, para, considering the entire submission made by Lana so and so video. Your interim bail was granted when?
This was granted on
6/12. Is it 6/12?
6/12.
6/12/2025 is hereby made absolute with the same terms and conditions. Okay. Yes, Mr. Patwari, don't do all these things. Okay. Yes.
I'll resume my reply argument
Yes.
on interlocutory application 2150 of 2024. Just to refresh myself, last time I submitted that under Article 324 of the Constitution of India, the RP Act has been enacted as a special law. RP Act,
yes,
I will call it RP Act, Representation of People. RP Act, there are different parts. Part 6 of the RP Act relates to, your lordship will look at part 6 heading. Part 6 relates to disputes regarding elections. Because in election matter, different things are there, nomination filing, scrutiny, all are connected. One chapter is dedicated for the purpose of disputes relating to election. And it commences from section 79 to 122. That is part 6. And part 6, why we call it a civil proceedings? If your lordship look at section 87, there is a section called section 87. Section 87 lays down basically what will be the procedure before your lordship to be followed in the trial.
Yes.
Same is the problem with this side also.
Okay, okay. This side also. Yes.
Because in
Whether it's comfortable, these things are not necessary now. It's raining outside.
Raining outside.
eyes also becomes very watery, so we can't read it properly. So is my law. So section 87, it lays down the procedure to be followed in the trial of an election petition. It says, number one, the CPC procedure will be followed, wherein Indian Evidence Act will be applied. Now, if we have a look from section 77 to section 122, that is part 6, there are different procedural sections relating to filing of an election petition. As for example, if your lordships looked at section 80A, it says where to file, High Court, how to file. Then section 81 says personal presentation, attestation. Then 82 says who should be respondents. 83 says what should be the contents. These are procedural sections. There are certain substantive sections as well. As for example, your lordship will look at section 98, substantive sections relating to the power of the court. Your lordship will look at section 98. What is your lordship's power at the end of the game is 3 types of orders your lordship can give. Your lordship can either dismiss my election petition, as your lordship, allow my election petition, or allow my election petition and declare me or any other candidate elected. These are the 3 kinds of reliefs only that can be given. And after that order is given, there comes the substantive power of the Supreme Court in an appeal under section 116A. The lordship will look at section 116A. That is an appellate power of the Supreme Court. As your lordship. Now, as when I say that there are certain procedural sections, may I take your lordship to section 81? Section 81 says that it shall be, as your lordship, it's a procedural section. Section 81 says that it shall be filed before the High Court, as your lordship got it. It shall be filed, second procedure, within 45 days from the date of declaration of the result. Next point, there is a conglomeration of procedure. Third point, that every copy should be attested. These are the next section is section 82. Who should be parties? 83, what should be the content? Now, interestingly, your lordship will now look at section 86.
Yes.
Section 86 says that if the procedural section 81, 82, and 117, 117 is the requirement for submitting the security while filing the election petition. If these procedural sections are not followed, 81 is not followed, 82 is not followed, or 117 not followed, court has, court trying the election petition has a substantive power to dismiss the election petition at the threshold. Now, a question that arises, that initially arose, that it will be an interlocutory order or what kind of an order, that dismissal order. That was made clear by an explanation. Your lordship will see, if the election petition is dismissed, it will be taken as a final order under section 98. Your explanation to section 86 is. Now, over the last 43 years at the bar, we have seen the way that handling of election petitions has gone for a change. Initially,
we found that after the filing of the election petition, we normally, I also used to do it. It's not that I did not do. We used to file an application for dismissing the election petition at the threshold by making an application under Order 7 Rule 11, read with Section 86. Because why Order 7 Rule 11 was, if your Lordship kindly look at Order 7 now, because CPC applies under Section 8. There is a clause called 11D, if my recollection is correct, Order 7 Rule 11D. In this calm atmosphere, well, it is very, in this calm and quiet atmosphere. No, no, it's closed.
This side
It is
also closed?
closed.
Okay.
I'm saying that in this absolutely vacant room.
Yes,
It
yes.
is really, when it is crowded, head does not work sometimes for me. If your Lordship look at Order 11 Rule, Order 11.
We
Section
created
D.
the calm, quiet and calm situation.
Yes,
For you all.
I favor this because if it is a really everyone shouting at the same time, then nothing goes into my head.
Okay, okay. Yes, 40,
Order 7, Rule 11, D. It says that election, plain here will be the election petition. Plain can be rejected at the threshold if there are A, B, C, D, E, F. Then your Lordship will see if the suit appears from the statement in the plain to be barred by any law. Now, what exactly we wish to do, since Section 686 gives a substantive power to the court to dismiss an election petition, invariably we will say that it is barred by 81, 82 or 117. Then so that the requirement of completing the trial within 6 months is gone. So that normally everyone does it. And here also we find 286 applications. So there are 286 applications. Now I resume my arguments on this. I have gone through the IA number 215. Here in this particular IA, the contention of the applicant, who is the returned candidate, he says in paragraph 5 of the application, if my lord can take the 215.
215?
I'm sorry.
Election petition.
215.
Yes.
If my recollection is correct, 215, paragraph 5. He refers to a filing slip as Annexure A and a checklist to say, checklist of the registry to say that it was not presented by the election petitioner, and this paragraph 5 is shown in the affidavit form as a true to information derived from the records. Your Lordship will see at page 10 probably the affidavit copy. That particular paragraph has been shown from records. Now this basic contention is filing slip number 1 and the checklist. There is no mention that it has been presented. So the requirement of Section 81 that it shall be presented by the election petitioner has been violated. Therefore, the court should exercise power under 86. Now, your Lordship will kindly look at the cause title of the application. 215 application. Cause title of the application. The application itself says that it is not maintainable. He is actually not filing any application under Order 7 Rule 11. Because of Section 87, he should have applied that. Application never lies under Section 86. Application is Order 7 Rule 11 read with 86 for the substantive exercise of the Lordship's power. The very maintainability of this application, I challenge. Now, at the preliminary stage itself, since CPC applies under section 87, it is my duty also to point out that under order 6 rule 15, there has to be a verification of pleadings. They have, because affidavit word came in 2002. Verification additionally an affidavit. Now, here there is no verification in the pleadings, unsubstantiated. The requirement in the bill of when it was introduced in 2002, that mere verification will not be sufficient. It has been additionally supported by an affidavit. The Lordship will look at order 6 rule 15. Verification clause was already there. 2002,
Yes,
along with that an
amendment.
affidavit came in because it became more stricter. Here in this, all the statements, these are enclosed, they are definitely an affidavit is there. But essential requirement of verification is totally absent. Your Lordship, at the trial stage, your Lordship has gone
Yes.
through that. Now I'll come to the merit side, because maintainability issues on these two orders, it is not an application under order 7 rule 11, nor it is verified. I am taking the whole thing head on merits. His basic understanding is that they were not present, election petitioner are not present, because he has derived this information from a checklist and a filing slip. That is at page 10 and page 11. Let us come to the merits. What exactly is the merit? Page 10, application in line. Has your Lordship. Page 10 হবো লাগিছিল।
Page 10 of what?
9.
Page 10 of I,
Page 10 I.
Hmm.
This is his basis.
filing form.
Filing form. Now, filing form in this Guwahati High Court's filing form, if your Lordship look at it, there is no mention of any clause presented personally. There is no mention. But even then, next page, in the same form, your Lordship will see the petitioner has signed. Your Lordship will see the next page, page 11. Bottom.
Yes.
But he is saying from this particular filing slip, no clause is there that he has presented personally. Now, he has also enclosed, normally when a petition is filed, registry prepares a checklist. The checklist also, page number 12. He says from this page number 12 also, there is nothing can be found out whether he has presented personally. So he has reason to infer, I underline the words, that it was not presented personally. I have checked up his application. He has not said, it would have been a different matter altogether. Had he said that at the time of presentation under chapter 8A of the Guwahati High Court rules, I happened to be present and I did not see the election petitioner presenting. And if he proves it, then of course it would have been a case against me. Now, let me check up what is order 8, chapter 8, Rome A of the Guwahati High Court rules, which is a special rule enacted in 1966. Has your Lordship.
Yes. Chapter?
Chapter Roman 8, capital A. Special rules, special provisions regarding filing of election petition. Has your Lordship.
Just read.
I'm sorry. It should be on the
Chapter?
left-hand side if the copy.
Page number, just tell us.
Page number is at 88.
80.
I'm sorry, my lord, sometimes.
Yes.
This is a special rule if my recollection is correct, it was enacted by the Guwahati High Court as a special rule in exercise of the constitutional powers for the purpose of filing of election petition. It says that election petition, rule 1.
Yes,
May I read, my lord?
yes.
The lordship will kindly see there are different clauses A, B, C, D. Has your lordship? Now, he has to attest as many copies as thereof. Let me read it from the beginning, my lord. Rule 1. An election petition under section 80A of the Representation of People Act may be presented duly verified in the form prescribed under 82 and 83 of the said Act before the stamp reporter. Requirement is before the stamp reporter of this court with a court fees of so and so affixed thereon within 45 days from the date of the election of the returned candidate, or if there are more than one returned candidate at the election, the dates of their elections are different, the later of those two dates. Every such election petition shall be accompanied by, has your lordship got it? As many copies as thereof, as there are respondents mentioned in the petition, together with extra copy, all the copies being fully attested.
Yes, yes. Good.
All the copies being fully attested by the petitioner under his own signature. Your lordship will kindly, because this is another basis, it is not own signature, that is another debate has come up now. Own signature to be true copy of the petition, and as many envelopes as there are respondents bearing requisite postal stamps, and there are different. Now note 2 is more important. Below note 2 has a lordship. Now suppose someone does not comply with these requirements, that he goes personally, attests it, what will be the consequence? Note 2. Note Roman 2.
Yes, yes.
Any petition which is presented out of time, that is one condition, and without, this is important, without any of the above mentioned requisites duly satisfied, shall be forthwith returned by the stamp reporter for refiling. It is not that like a writ petition anyone files and kept it in the defective section. It will be returned forthwith. Next, after, if it is not returned, then it will be presented before the Chief Justice, next clause, for designating an honorable judge as a trial judge, by so of which your lordship is now trying. Now, he in paragraph, most probably in paragraph 9 or 10, he has said, paragraph 8, I'm sorry, I stand correct. A bold statement has been made that election petition is not maintainable also on the ground of non-compliance with the procedure prescribed by the honorable court. Which procedure? Now the question is, there is, because it being a statutory, it's being a rule under special rules and being backed by the constitution, Guwahati High Court rule Guwahati High Court exercising, which special rule was violated? Nothing is there. Now your lordship has on an empty number of occasions have dealt with the Evidence Act. If you want me to believe something, burden is on you under 100 section 101 probably. Let me check up. Now Evidence Act 101 2. At one stage of the life, sometimes we too much rely on the memory. Yes, section 101. It says the burden of proof in a suit or any proceeding lies on the person who would fail if no evidence at all are given in that suit. Primary burden is on him first. And he now cannot say, one cannot give evidence of what is not pleaded. Now he says some rules are violated. The material fact, which rule is violated? Some rules are violated. That is a vague pleadings. For vague pleadings, and not discharging the burden as required under section 101, ultimately this is not sustainable. Now, basically, on these two grounds, he says that one is checklist and the filing slip, one is the rules violated. And had it been violated, the registry's requirement was to return it then and there. The presumption is in my favor that I have fulfilled the requirements. It would have been a different case. Had I been in the other side, I would have definitely pleaded one thing, that for some reason, I was present also in the room, registry room. I did not see the election petitioner coming personally to present it. Then I bring in some witnesses to prove that statement. Now that pleading is not there. The question of bringing in now evidence doesn't arise. So now, on PSL 2151. Now, these are my arguments, my lord. So under order 18 rule 3 capital A of the Civil Procedural Code, may I have the indulgence of your lordship to keep on record the synopsis of what I have argued, and then order 18 rule 3 my lord will just order 18 rule 3A capital A, because I have to take your lordship's leave before submitting. Possibly that was the language. Lordship has dealt with on this in the trial court. This lordship has dealt with. So this synopsis I have filed, and so far I am concerned, my lord, for a 215, I have completed my argument. Yesterday I told your lordship that I will take not more than 15 or 2, exactly 20 minutes. I am obliged, my lord. I leave it to my learned colleague for the reply argument. Why the reply argument?
Perhaps my learned friend, while giving reply, has not given reply to the other point we have raised there. In fact, we filed for IA to counsel. No, 88. In the IA, we have raised basically two issues. One is not presenting the petition in person. And the second is in terms of the second point was, let me see the paragraph. Paragraph 9.
Yes, I'm thankful. Can I address it or not?
Yes, always.
My lord, I'm sorry for it. Here's another third allegation that also I have, in the last sentence of my summary, I covered it up. His third allegation was the requirement of section 81 is that I am required to give as many copies as there are for the respondent.
That was raised by yes.
And that is also the requirement of the special rules, as just now I have pointed out. He says that I have not given it. Had I not given it, then note 2 will apply. It would have been returned to me immediately then and there. That I have covered. I'm sorry. Thankful to you. In fact, I forgot that.
May clear out. Yes. Well, I have basically raised two very simple issues. As your lordship has seen in section 86, Section 86 is absolutely clear. If there is non-compliance of section 81, 82 and 117, the petition has to be summarily rejected. I need not take my submissions, my reply submission. I need not take the or I need not invoke Order 7 Rule 11. Order 7 Rule 11 is to be invoked in the special circumstances mentioned in Order 7 Rule 11. Either I say that the suit, or in our present case, the petition is not maintainable because it is barred by any law. If your lordship goes to Order 7 Rule 11, Order 7 Rule 11 says rejection of plaint, the plaint shall be rejected in the following cases where it does not disclose any cause of action. One is if it doesn't disclose any cause of action. 2, B, where the relief claimed is undervalued. We are not concerned with that. It doesn't disclose any cause of action. That also we are not saying. And C says where the relief claimed is properly valued, but the plaint is written upon a paper insufficient stamp. That also we are not saying. D says where the suit appears from the statement in the plaint to be barred by any law. My learned friend is basically referring to that. If you are praying for rejection of the plaint, then it should have been under Order 7 Rule 11D. No. It is not a case where we are saying that we are praying for rejection of the plaint for want of any cause of action, or that it is undervalued, etc., or it is barred by any law. In a petition where in a suit rather, so far as election petitions are concerned, wherever there is invocation of Order 7 Rule 11, it is only under Order 7 Rule 11 Order 7 Rule 11A for want of cause of action. And lordship will find that in most of the cases, a petition is filed, in a combined petition is filed under Order 6 Rule 16, read with Order 7 Rule 11A, because there the basic prayer is for striking out the certain paragraphs of the election petition on the ground that those paragraphs do not contain the material facts, and material facts including the particulars in the case of petition and for a practice. So where there is a allegation by the written statement, by the respondent in their written statement, or even before filing the written statement, that because of want of material facts or want of material facts plus particulars, the petition or some of the paragraphs do not disclose any cause of action. And once those paragraphs are struck out from the petition, then the petition is left with no cause of action. It is in those cases, my lord, a petition under Order 6 Rule 16 read with Order 7 Rule 11 is being filed. But here is a case we are not concerned at all with Order 7 Rule 11, because we are not saying that the petition does not disclose any cause of action or there is want of material facts. That we are not saying. Our contention is there is non-compliance of Section 81.
It is stated.
Our contention is there is non-compliance of Section 81. Now, if your lordship goes to Section 81, and that is why we have invoked only the power of the court under 86. 86 very clearly says High Court shall dismiss. This is absolutely a substantive provision whereby the statute has conferred upon this honorable court a jurisdiction to dismiss an election petition in an event where under Section 8 there is non-compliance of Section 81, or there is the non-compliance of Section 82, which speaks back about parties matter. In an election petition, if this necessary party is not impleaded, as my lord interpreted in Jyoti Bosu's case in 1982, Supreme Court, my lord, that if there is non-compliance of Section 82, the election petition will be dismissed under Section 86. Similarly, my lord, 117 is also mentioned here. The requirement of depositing security of rupees 2,000 at the time of filing election petition under 117 is a mandatory requirement. If there is a failure to deposit the make the security deposit of 2,000, then also section 86 can be invoked. But here is a case where we have invoked 86 for non-compliance of section 81. Now, which part of section 81, my lord? If your lordship goes to section 81, lordship will find an election petition calling in question any election petition may be presented on one or more of the grounds specified in subsection 1 of section 100 and section 101 to the High Court by a candidate, any candidate at such election or any elector, etc. Now, section 81 came up for consideration, interpretation in one of the judgments which I have relied on, my lord, where it has been clearly mentioned that at the time of filing the election petition, the petitioner has to remain physically and personally present in the before the High Court or before the registry to present it. Now, this section 81 doesn't say that he has to be physically present. It is the interpretation given by the Honorable Supreme Court, which has become a law, my lord, under Article 141 of the Constitution of India, and all of us are bound by it, my lord. G.V. Sri Rama 2009 ATCC 736. If necessary, my lord, I have already had it over. Relying on some of the paragraphs of this case, I have argued that there has been non-compliance because it was not presented by the petitioner in person. Now the question is, what documents I have relied, how I have verified. Verification part I'll come at a later point, my lord. So far as the burden of the present applicant to show that the petition was not presented in person is concerned, my lord. Lordship has this copy of the original election petition is before your lordship. I have also argued, my lord, that on the first page, it is the general practice, my lord. It is the general practice that in order to indicate that you have presented in person, my learned friend is well aware that I need not, my lord, say anything. Every election petition, when we file on the first page itself, it is not unlike other petitions where it is mentioned that the writ petition or any other petition presented, it is filed by the advocate. But in an election petition, it is not filed by the advocate. It is filed by the petitioner, and there he will put his signature. And he will also write that it is in person. My lord, there are, I am told, about 10 to 11 election petitions filed in the Itanagar Permanent Bench of this Honorable Court.
Yes.
In all those cases, my lord, it is mentioned that it is filed by the petitioner, that is the election petitioner, not by the council, my lord, and in person. Unfortunately, my lord, in this case, your lordship will find in order to indicate that it was presented by him in person, on the first page of the petition, there is absolutely nothing, only one signature. And my lord, it is on record that we have filed another application challenging maintainability on the ground there. The signatures which are there in the election petition are not his signature. And we have mentioned, we have filed a separate IA. Today, I am not arguing, I am only indicating that this signature also is not of the election petitioner. That is a different issue, my lord. But then first page of the election petition, lordship will kindly have a look at the election petition. The main petition which he has filed.
Yes.
Apart from signature, I think there is nothing else that it is filed by him in person. It is there, na? Election petition is here.
Yes. Yeah.
My lord. Lordship will just have a look at the petition. I am holding my copy only, which was served on us. It doesn't mention that it was filed by the petitioner and in person. This is the first aspect. Secondly, my lord, lordship will find if it was really presented by him in person, it is the filing form and the checklist which will indicate that he has presented in person. Now, my lord, fortunately, we took certified copy of this filing form because we apprehended that there may be subsequent, I should not use the word manipulation, my lord, but it is more than that. I indicated at the time of arguing my IA, my lord. So far as filing form is concerned, there is absolutely no indication in the filing form that it was presented by him in person. It is the filing form and the checklist which will indicate how, in what manner, when the election petition was filed. There is absolutely no indication in the filing form at page 10 of my IA that it was presented by him in person. Now, which is more serious in this case matter, and possibly this will clinch the whole issue, is the checklist annexed at page 12 of this IA, madam. I argued at that time of my argument, my lord.
Checklist as page?
At page 12.
Yes. Yes.
Now, this checklist contains name of the district, case number, then code, filing slip, date of filing, signature of DA, then DA possibly the dealing assistant. Then there is a line, this WPC revision application is defective for the following reasons. Some reasons are mentioned. Then there is page, next page, page 13. My learned friend may also be, my learned friend may verify. At page 13, there is a serial number which contains the sentence, any other reason if any. Now it mentions a challan of rupees 2,000 deposited into the SBI as security for the cost of the petition. So far as the, my lord, certified copy of this which we have obtained, we have annexed with the IA. I think the certified copy we have annexed with the IA with a copy to my learned friend, my lord. This sentence is there. Now, in the record, you also will find this checklist is still available. Lordship, may kindly have a look at the checklist now. I'll checklist. We will find out for it.
We'll find it. Checklist. First check for different checklist.
Madam, my learned junior will assist just to find out. Checklist. This is a Xerox copy, it's not the original petition.
Oh, no, however, maybe Xerox, but no, that will be one of the issue now. Original is there in the Arunachal.
Itanagar.
Itanagar.
And on the, if your lordship recalls on the last occasion, I pointed out that after this serial number 21A, one line was subsequently amended. Put,
Yes,
if your lordship recalls, in the presence of my learned friends, I argued. How the line comes. Piece of yes. And we read it and we have written by ourselves. A second line was inserted subsequently, which says chapter 8A of the Guwahati High Court rules 1A. 1A relates to the number of copies to be served for the number of respondents.
So now from the checklist, what do you want to submit?
From the checklist, I want to submit that subsequently, my lord, subsequent to the furnishing of the
copy
filing of the petition, and after we obtained a certified copy, because we apprehended something like that. So we obtained a certified copy, we filed it along with this IA. Now, after we filed the IA, this one more line was added. By whom and in what manner we do not know, my lord, which says chapter 8A of the Guwahati High Court rules, rule 1A has been filed and has been filed along with the petition. There is a reason, my lord. The reason is the second ground we have taken in this IA is that the adequate number of copies for the respondents in terms of rule 1A of chapter 8A was not complied with. Not only that, my lord, this requirement, so far as High Court rules is concerned, it is mentioned in 1A, but in the Act, section 81, it is absolutely clear. Section 81, subsection 3 says, every election petition shall be accompanied by as many copies thereof as there are respondents mentioned in the petition, and every such copy shall be attested by the petitioner under his own signature to be a true copy of the petition. Meaning thereby, that if there are 10 respondents...
just a second, Wajibra. So you raised those issues that they have regarding his personal presentation of the file and the other issues that as many as the copies or the envelopes should be there or not. So in that regard, Mr. Pathak has submitted that note 2. Note 2 is very specific, wherein if there is any such kind of thing, it has to be returned back to this source.
I'll reply.
In that regard, you will just reply.
I'll reply.
Okay. So we have, okay, then this is dinner. One line is added there.
Yes.
Oh.
And what is the purpose of inserting this line? This line naturally is in favor of the election petitioner. Now, going strictly, there has to be a formal and proper inquiry as to who has manipulated this record of the Honorable Guwahati High Court. This is a very, very serious issue. After filing of the election petition, when an IA is filed, alleging non-compliance of a particular provision of the Act, which is mentioned not only in section 81 of the Act, but also in rule 1A of chapter 8A. Then one line is subsequently inserted without the permission or without the leave of the Supreme Court. That goes to show that there was non-compliance. This is the presumption. Nothing else is required in this case, my lord. Nothing else is required. moment we find that after filing of the IA, somewhere from somebody writes one more sentence. That rule 1A of chapter 8A of the Guwahati High Court rules has been complied with. That clinches the issue that there was no compliance. Well, not only that, that is only one part. The other part of this allegation is, as I mentioned in my IA, Lordship may kindly say, my Lord may kindly turn to page 17 of my IA. No. Okay, no.
Yes.
My Lord, Lordship will kindly record what you are in
Page 17.
Yes, Lordship will kindly, I will check it records. One more thing will point out. Page 17 is the first order passed in this case, madam. My learned friend appeared. I am skipping the first 2-3 paragraphs. Thereafter, in the middle, Lordship will find issue notice to the respondents, returnable on 22/8/2024. Now comes, this is important. Learned counsel for the petition is hereby directed to take steps for service of notice upon respondent number 1 and 2 by registered post with AD, as well as by usual process within a week from today. In addition to that, as prayed for, the learned counsel for the petition is also allowed to take steps by the mode of service which shall be routed through the registered dispute. Now, this order was passed on 30th of July 2024, my lord. And in terms of this order, they have taken steps on 1st of August. It is mentioned in the notes, office note, my lord. Lordship will kindly take the office note part, which shows that steps were taken on 1st of August 2024. So the office note and this order is absolutely clear that for the service of notice along with the copy of the petition, the copies, extra copies required to be filed along with the petition in terms of section 81 subsection 3 were actually submitted on 1st of August. And this is in clear non-compliance of section 81 subsection 3, which says that along with the petition, the extra copies will have to be served. Otherwise, it is non-compliance of section 81, leading to the consequence as mentioned in section 86.
But how? How can you say that? I mean, order was there.
My lord, the procedure is, my learned friend is also aware, I also have been doing it when I was a raw junior. My lord, when an election petition is filed, the petition will be sent to the registry for the purpose of weighing. This is the procedure, my lord. For the purpose of weighing is to find out as to how much of postal stamp will be required for sending it to the respondent's address. Number one. Number two, written up, it is mentioned in the High Court rules, written up notice. The notice that will go will also have to be submitted on the first day of the filing of the election petition. Second. Third, adequate numbers of copies of the election petition. Then the envelope containing the address of the respondents, all the respondents. Then one AD card containing the address of the addressee and also the sender. All these things are required to be filed along with the election petition on the first day, not after your lordship passes an order. I am not saying that your lordship's order is wrong, etc.
No.
What I am saying is, when this honorable court passes an order, had they filed the adequate number of copies at the time of filing the election petition, they would not have been required to file another copy on 1st of August. Number one. Number two, my lord, most important is, while we file the election petition for the purpose of these things, adequate number of copies of election petition, written up notice, AD card, envelope, postal stamp, one talabnama is to be filed containing all these materials. That talabnama will be the document to show that when the steps were taken, because steps were not taken on at the time of filing the election petition, and it was taken on 1st of August, is evident from the fact that the Talabnama copy is not available there. My lord, there are records of hundreds of petitions lying before the Supreme Court. In all such petitions, this is the procedure followed. To show that at the time of, because otherwise, other than that, there is nothing on record to show that election petition was filed along with the adequate number of copies for the respondents. And had it been filed, this order was not required. Your lordship had to pass the order because it was not filed. And till date, there is nothing to show that it was filed. So there is no question of any presumption under any note, etc. You have not complied with the requirement of section 81, which is also mentioned in the High Court rules. My lord, High Court rules, chapter 8, rule 1A says, every such petition shall be accompanied by as many copies thereof as there are respondents mentioned in the petition, together with one extra copy. Not only that, my lord, along with that, if there are 3 respondents, 3 copies plus extra, apart from the original petition. So this is the requirement. These requirements we have learned from my senior.
Only one thing, if he doesn't mind, or if he doesn't take it otherwise. I have the counsel with me from Arunachal. Your lordship, while passing the order on order to be seen,
2nd July.
on 30th of July,
30th July.
in addition to the direction for issuance of notice by usual process, also invoke the power under Order 5, Rule 9A for Dosti service. For the Dosti service, the copies have to be given because what is provided in the rules is the copies in the usual service. If your lordship looks at the order, there is a 2-part that they are also allowed to take Dosti service. For the Dosti service, since the power was exercised, they have to give more copies than what was given in the rules. For every person, he has to give 1 extra for Dosti service. That's what most probably has been confused now. I have taken the instruction. That is, copies are given. Otherwise, had it not been given, it would have been returned back. Now, copies were given, but there is an additional order in your lordships on 38 for Dosti service under as provided, that power is provided under Order 5, Rule 9A. Order 5, Rule 9A. That is the 3rd paragraph. And for implementing the Dosti service, he has to give copies. For usual notice, one has to give. He is correct. He is correct that for usual notice, to the registry, copies with 1 extra. That was complete. But there was an additional order for Dosti service. That is what my learned colleague found.
So my submission is, even if we go by the order passed by the lordship on 30th of July, 2nd paragraph speaks about Dosti, but 1st paragraph speaks about the original notice to be served. And in the 1st paragraph, your lordship had to pass this order because steps were not taken. Had it been taken, they would have immediately pointed out that no, there is no requirement of taking steps because we have already taken steps under the rules and under the act. On the 1st day of filing of the petition, this has to be submitted. And in the absence of such compliance, the section 81 will be attracted and therefore section 86 will be attracted. It's an absolutely open and shut case that steps were not taken for the purpose of respondents. I mean, copies were not served in terms of section 81 subsection 3, and which is also mentioned in rule 1A of chapter 8A. Realizing the mistake, my lord, after the petition was filed, IA was filed, 1 more line was inserted. I am not going to the extent of directing, paying for it before your lordship to direct an inquiry, because who will go to jail, nobody knows. It's a very serious offense, my lord.
Obviously.
Very serious offense. It will lead to an inquiry. Thereafter, who will go to jail, nobody knows. But fact remains that there was no non-requirement, and had there been a compliance, this line would have been there prior to we obtained this certificate copy. And we apprehended that this kind of things will happen. I instructed my learned friend, when my learned friend said that this is the position of the checklist and memo, I said, please obtain certificate copy. You never know, the whole thing may be removed. Today, when my learned friend was searching, my madam was searching, it was not there. I was apprehending, maybe subsequently the whole thing has been removed. At least fortunately, it is there till now. So these being the position, it is very absolutely clear. There has been non-compliance of section 81, so far as the number of copies of election petition to be served along with the election petition is concerned, is absolutely clear. So far as the presentation is clear, concerned, my lord, the election petition is itself is a very clear thing that it was not presented by him in person. And for that, my lord, I relied on this judgment. I relied on one paragraph, and I'm just pointing out that paragraph once again. The my lord, compilation that I have given containing the cited judgments, my lord.
Yes.
Possibly it is lying in Itanagar bench, I don't know. Maybe I'm just slowly reading one particular page. Also may take a note from this compilation. Page 6 is the judgment of G.V. Srirama Reddy. Paragraph 19, one can discern the reason why the petition is required to be presented by the election petitioner personally. An election petition is a serious matter with a variety of consequences. Since such a petition may lead to the vitiation of a democratic process, any procedure provided by an election statute must be read strictly. Therefore, the legislature has provided that the petition must be presented by the petitioner himself, so that at the time of presentation, the High Court may make preliminary verification, which ensures that the petition is neither frivolous nor vexatious. And relying on the judgment, one of the election petitions was dismissed by the Honorable Court, where I had the opportunity to appear for the petitioner, and my petition was dismissed because it was held that it was not presented in person. In response to this,
here one more question is there. Presented personally, you have raised the issue, but signature of the petitioner is available.
Signature is available, and so far as signature is concerned, we have filed a different IA that will also take.
That is okay. Then that is okay.
Signature is there, so far as this IA is concerned, my lord. But then he has not. Signature is one thing, but he has not presented it in person. Assuming for the time being, for the purpose of this IA, that it was signed by him, but unless it is presented by him, remaining physically present in the court, it will not be maintainable. This is what the Honorable Supreme Court has said in their judgment, and relied on by this Honorable Court in the case of Sukhato, which we have given at page 23 of this IA. 23. Relying on this judgment, my lord, compilation. Now, my lord, in response to this, reply has come from the respondent in the IA that had it been a case where the applicant in the IA had said in his application that he was present there and he saw that the election petitioner, while presenting his petition to his counsel, was not physically present. With all respect to my learned friend, under other circumstances, I had to give such reply. But with all respect, once again, I'm saying, my lord, this will be an absurd proposition. The respondent returned candidate cannot be expected to remain present in the registry of the High Court, one person in Guwahati, one person in Itanagar bench, for 45 days, which is the period of limitation, to observe as to whether the election petition is filing the petition in person or not. That is an absurd proposition, my lord. So that argument need not be taken into consideration. It cannot be expected of a person to observe 20 all official hours of the day, whether the petitioner is coming with a petition to present it in person. It is from the record, my lord, it has to be ascertained. Records are absolutely clear. One record is election petition is silent, that it was presented in person. At least there should be something on the petition. Unlike other petitions, in this case, there is nothing to show that he has presented it in person. Number one. Number two, my lord, checklist and filing form, both are absolutely silent about My lord, I have relied on one more judgment of Chandan Kumar, which is reported in AIR 2018, Guwahati page 1. I have given in this compilation, where this Honorable Court has said the report of the election petition has to be in the present, in this manner, my lord. He says, Lordship may kindly see para 10. The report of the election petition. The election petition has been filed by the petitioner today on so-and-so personally during the office hours. The petitioner is present and signed each of the pages of the petition, annexures and series of copies of the petition in my presence. The petition along with a spare copy for the office use within 45 days and in form. The petition has been supported by an affidavit, etc., etc. And then 4, my lord, 9 numbers of written up notices have been submitted for service of notice upon the respondents. Then security deposit, etc., etc., wakalatnama, etc. These are not there in this case. So there are sufficient materials, even if it is presumed that initial burden is on the applicant, applicant has discharged this initial burden to show that the petitioner did not present the petition in person. And secondly, so far as the requirement of section 81 subsection 3 is concerned, it is absolutely clear. There I need not show anything. It is for the records to speak that through the talabnama that the adequate number of copies for the respondents along with the written up notices, then ID card, then postal stamp, etc. were filed on the day of filing the election petition. And the talabnama will testify to all these facts. It is absent because it was not taken. And the now further record is available that after your lordship passed the order on 30th of July 2024, they have taken steps and all the requirement of section 81 subsection 3 was complied on 1st of August, which is definitely after the expiry of the period of limitation of 45 days from the date the result of the election was declared. Within 45 days, they could have rectified that, but that 45 days have elapsed in the meantime. And my lord, a last submission was made about verification, absence of verification in my IA. In terms of order 7, order 6 rule.
Rule 15.
15. So far as so far as this submission is concerned, my lord, my reply is very simple. This requirement of verification was all throughout there. It is only after amendment of 2002 of the Civil Procedure Code that the additional requirement of filing affidavit in it is order 6 rule 15, my lord, that filing affidavit in addition to verification came, but this is for the purpose of pleadings in a suit, my lord, and pleadings mean plaint and written statement, not other petitions, my lord. This is my first submission. An application filed under a provision of law subsequent to the filing of the suit or in a present case subsequent to the filing of the election petition is not called pleading, my lord. It is called averment in the petition. Pleading means that what is mentioned in plaint and written statement. And if there is subsequently an additional written statement with the leave of the court, that will also be pleading. But any other petition subsequent to the filing of the suit during the trial, my lord, is not pleading. It is called averment in the petition. So this requirement of filing verification and in addition to affidavit will not come in the case of an application. This is my first submission. Second is, my lord, in our case, we have filed an affidavit and the objection is that there is no verification, only affidavit. My lord, my learned pen has made this submission. I know, my lord, why this kind of small points are raised. Well, affidavit is also a verification. Lordship may kindly see the language in the verification and affidavit. My lord, in the verification, the person has to verify the statements. Verify the statements so as to bind the person with the nature of responsibility he is taking for the averments made or for the pleadings made. If you say that it is true to your knowledge, you will have to prove that it was available to you directly, and you are basing it on the basis of your own knowledge. If you say that you are verifying it true to your information derived from the document or the, my lord, record, then you say that I verify it to be true to my information based on the record. So the language mentioned in the verification and affidavit are same. Both are verification, but the difference is in an affidavit we do it on oath. In verification, there is no question of verifying the statements on oath. There is no other difference. Both are verification. Well, I did not teach this on the court and my learned senior. My learned is well aware, and I can understand why this kind of small objections are being raised. There are reasons. So petition is. But if my learned friend gives a argument, then I have to give a.
No, he will give only one thing I want to clarify. Let him be on look. I'm just now told that election petition has been shown before the oath commissioner in the registry, which shows his presence before the oath commissioner, and that personal present he was there because oath commissioner has signed, because it is not notarized outside there and presented. This is number one regarding personal presentation. Second, regarding the service copies given on first, is actually there was an additional, because I was the counsel who was present, because there was a requirement in under section 87 of the RP Act for completion of the trial within six months. And normally the procedure of the tricks of a return candidate always is how to avoid the service. So therefore, with responsibility, I made that statement, which your lordship was kind enough to accept it, for a dusty service required under Order 5, Rule 9A of the Code of Civil Procedure. For this additional direction, the steps were taken. So these are the two things I wanted to clarify. Oath commissioner, it was done within the registry. Second was, since there was a direction, there is a mandate of law for completion of the proceedings within 6 months. Since my experience shows that people normally avoid. So I prayed for 6 months, so keeping that mind of 6 months timely, I prayed for dusty service as well, which your lordship was granted and directed us to take steps. For the dusty service copies, I am told by my learned colleague from Arunachal, he gave the copies.
Anyway, madam, I again stick to my reply here that there are two parts in a lordship's order. First part speaks about the steps to be taken. It's not dusty. It is the original requirement of supplying the adequate number of copies at the time of petition. The first part doesn't speak about dusty. Secondly, my lord, dusty service is foreign to the whole concept of, my lord, election jurisprudence. There is no question of any dusty.
Every case we take.
So, my lord, first part speaks about the steps to be taken, copies to be furnished, along with the election petition, which speaks about first part. So, first part cannot be confused. Second part is dusty. So, we are not concerned with dusty in this case. Our simple contention is there. Along with the copies, it is nowhere mentioned. But unless, my lord, it is mentioned somewhere, it is the talabnama I am repeating, my lord. It is the talabnama which contains the contains the statement as to what are the documents filed along with the petition. As I have said, my lord, all these things are to be mentioned in the talabnama. It is there in each and every case, but unfortunately in this case it was not taken, and subsequently with the leave of the Supreme Court, steps were taken on 1st of August after expiry of the period of limitation. Therefore, the petition is apparently, my lord, not maintainable for non-compliance of section 83, subsection 81, subsection 3, read with the High Court rules. And so far as presentation is concerned, I have said there are enough materials that it was not presented in person. So on these two counts, my lord, the election petition is not maintainable, Lordship will kindly dismiss the election petition under section 86 for non-compliance of section 81 subsection 3 and also for not presenting it in terms of section 80. That's my sense.
Okay. So I can obtain from the Arunachal also this
Yes,
compilation.
yes, ma'am. If necessary, I can submit because ultimately your Lordship will have to make use of that original record because of this nature of
yes,
arguments they made.
yes.
So that copy is available to your Lordship and in that record.
In that record.
Yes. If your Lordship so desires, then I can make extra copy and submit before Lordship tomorrow.
But you make an extra copy because I
Will
missed
make.
a dictation here in the principal seat
Tomorrow
also, I don't know.
Tomorrow
At the time
itself.
of file. Oh,
Tomorrow
okay.
itself.
Okay.
Huh. I'll furnish tomorrow. Take it. The Lordship may retain it. I'll collect it from the record subsequent. Lordship may now retain it.
Moku dibi eta copy.
Oh, the attack copy.
Moku dibi. It's a pleasure appearing before Lordship.
Obliged.
The order reserved. Will be
My
reserved. So you are going back or staying to here?
Going back here.
Going back. Bye.
I just today itself I came from Delhi.
Oh.
It's morning.
So you're going back to Delhi or Arunachal?
Arunachal.
Arunachal. And otherwise everything is okay in Arunachal? What about the progress of that bridge in Hatimatha? Is there any progress? Hatimatha bridge is there or what is flyover is there? Na? Flyover?
Still the same. That's why
Previously, when late Nagan Saikia sir used to take me for some private briefs, there was a wooden bridge in Bandardawa. And before that wooden bridge, there was no bridge at all. And Saikia sir, out of fear, Nagan Saikia sir, now his son is also, he will get down from the car and he says that you be in the car because I said that if you are scared, I am also scared. Then we will used to pass through. That time it was a bench, only a circuit bench or something. Saikia sir was Advocate General those days. That was in 98, 97 that time.
Okay.
Now things have literally improved after the last time governor intervened and that Gopur road has come out.
Yes, now, yes.
Now, and that Bishwanath Sariali area, now it is quite good.
We go by that road only. That Bishwanath Sariali and
Holongi.
Yes, Holongi.
Previously that Holongi gate was not there. We have to go via Narayanpur.
Oh.
Then Bandardeva gate. And after crossing Bandardeva, there was no connection. We have to cross the river with the car itself.
Okay.
And looking at Saikia sir's face, I always used to say, you don't ask me to sit down, I will also get down here.
Okay.
The river did not have any bridge, although water level is not very high, but one has to go through the river. That was the position.
There was another very bad road.
It is in Naharlagun near Nirjuli. My learned friend from there will.
And yet there is another route, via Laluk.
Laluk, yes.
I was given, when I was ASD there, I was given in charge of enquiring a particular hill transport subsidy scam. So for some security reasons, I was transferred to Lakhimpur. From Lakhimpur, I used to go via Tea Garden that connects to now present High Court around that area.
Oh.
And that also was a very bad road.
Hmm. Anyway, we're getting a good building, na, Mr. A very good building is now.
has started
We're
on-
going to inaugurate on in month of August, I think so.
July.
Oh, that will be good.
June or July, they are going to hand over the matter.
9th of June or August.
9th of, no, June or something, July, most probably June. They're going to hand over the building and then inauguration will be there.
Because we can have sittings here.
Yes.
Because having a sitting, provided the courtroom is good and all, we get relaxation. Although it is difficult for the court to, because we have nothing else to do. We can have the evening chit-chatting and all.
Yes, yes.
We two lawyers are completely free after appearing in the court. Obliged, Your Lordship.
Alright. Any other matter?
No, I have another
No,
matter.
then we have to wait.
No, another matter.
No, we have some other matters.
Fine.
Etiquette of the court demands that we should go ahead.
Yes.
Yes.
For others, item 32.
I asked. 32 was simply most probably one extension prayer was there, I think, in item 32.
No one is there now.
A2 for us, AB2 name, what is AB name? AB or AB? AB2 sounds right. This is also fixed today, AB also. 16 flag is fixed. It will for 1 week. So one appeared on behalf of the petitioner. List the matter accordingly after 1 week as an date to be fixed by the registry. Yes, Mr. Day, you have one.
I'll be seeking some accommodation. Case of 2013.
I also seek
Well, I understand.
accommodation.
I understand, your lordship is exhausted.
We have some work also in the actually.
Next week, Milord, probably because I'll just collect the brief, Milord. In fact, the brief is with my colleague who is in the FT now.
Oh, your brief is missing in fact.
Yes, Milord. In fact, he was with me, Milord, but subsequently he joined FT.
Oh, this is a case of 2013 in fact.
Yes, Milord, probably it was a conviction under 498A. Milord. The
498A.
Husband as well the
just tell us what is the term of the sentence?
It was 6 months for the, so far I recall, 6 months for the husband, and fine was imposed on the parents, parents-in-law.
Oh, they are not inside the jail.
In fact, bail was granted.
Okay. Okay. Yesterday, I don't know, not yesterday. I have seen in the paper today one person was granted bail. Most probably it was a prayer for in the High Court. Most probably it was bail was granted to one person. He is from maybe from Morigaon, or I just forgot, from Dorong, I think. I forgot. After obtaining the bail, the allegation of committing some sexual assault on the daughter of the informant.
Yes.
And yes, after coming out from the jail, he
Again,
already committed murder of that wife. So very, very dangerous now. To take revenge or whatever, I don't know.
Okay, yesterday there was a case here, POCSO matter. Yeah, after releasing on bail, my lord, first case, he again went and committed the same offense. With the victim.
Anyway, Mr. Day, then next week and
any date will allow.
And hearing days next week 29/5. 29/5 will tell me. In the meantime, definitely will get your brief back.
On Saturday, I'll be getting.
Okay, okay. So he is in FT now.
He is in October.
Okay. Into positive issue of 29. Oh. Right, I did request to cover, but. Okay, then we are fixing it on 29.5. So tomorrow also same issues are there, grounds of arrest and all.
Same issues.
Huh?
I am the culprit it seems.
Nowadays, in all the matters we are hearing on the grounds of issues, ground of arrest, mentioning, non-mentioning, 47, 48, 50, we are on that only. Let's
Yeah.
hope if any outcome is there from the Honorable Supreme Court in the matter which is pending before the court.
The jails are getting cleared.
Yes, yes. Now it is to everything is.
Especially Karimganj. Sar, future area.
Yes, yes. Only the convicted ones are there. They are relaxedly there residing inside.
Yesterday, someone told me now the convicted persons who were there, they are very happy because they are getting very good food now. Because earlier they are due to overcrowded, they used to
Has
get
to be shared.
less food.
Mm.
Now they are getting like in a breakfast they are getting bread and fruits
And
and all these
if
things.
you go inside the jail environment is very good. In
Environment
Kamrup also now, these hilly areas are there, the city seats there, the musical eating is there, some are in acts also, I mean drama is there, and computer sections are there, schools, everything is
Everything
there,
is
painting section, there can be busy. Otherwise, it's okay, good only. Rakesh Pal was also staying more.
Built one
Satsang,
Namgora Mandir there.
They have a
Oh.
mandir there, the Satsang mandir inside.
Oh,
And most of the convicts, they have been, Christian under the Satsang community.
Oh, acha.
Even so far, probably Sarvananda Savnath is the CM, he went there for the inauguration also.
Acha, very nice. That is one kind of, I mean,
yes,
incentive or initiative to them.
But still, we don't want to go inside.
Okay.